May please, Your Lordship. Item number 48, I recommend item number 48 on behalf of the respondents, Mr. H. Gupta.
40.
48. On behalf of H. Gupta for CGC, Lordship, with the consent of the other side.
On behalf of? You are making a mention on behalf of?
H. Gupta, CGC, for all the
All
respondents.
right. Item 48, from the request made on behalf of
48.
the security matters stands deferred to be listed after 3 weeks. It is submitted that consent of the council.
All right, please, Your Lordship. In item number 28, we have filed the affidavit on behalf of the respondent. The records of the same may kindly be clear.
28.
28,
Affidavit for the respondent.
on behalf of the respondent.
With the consent of other side, Lordship, I beg to mention item 24 of the daily list, Lordship.
Yeah.
And we have a respondent side, Lordship. The affidavit has been sent for vetting, Lordship. Some more time may be given to file.
Yes. The Lordship, they have given the consent to file an affidavit. The request made on behalf of the Departmental PNRD, further 3 weeks time granted to file their affidavit. Council for petitioner does not object to the prayer, at least after 3 weeks. The Lordship allows the date may be fixed. After 3 weeks, you make a mention.
Okay.
May I please, Your Lordship? Lordship, I beg to mention the petition number 6394 of 2024 for listing, my Lordship.
That is in court number 5.
May please, Your Lordship.
Number 5.
May please, Your Lordship. I beg to item number 47 of today's list, Madam. I beg to submit on behalf of the team AD Pavitra Modi CGC, Madam. I have already taken consent of other side also.
47.
47, yes.
The request made on behalf of the CGC matter stands deferred to be listed after 3 weeks.
Lordship, I have objection, Lordship.
Does not object.
Yes.
Yes.
Lordship, I have objection. I am for the petitioner.
Oh, you have an objection.
Lordship, last time also they also took.
Then you
Then
wait
okay.
when the matter be called up.
Then I don't have any idea what it is. Sorry.
Wait.
Lordship, I beg to mention item number 23 on behalf of the respondent. Kindly give us 2 weeks time.
23. 23.
Yes, Lordship.
23. You are for the respondent.
Yes.
Have
Lordship,
you
I am for
informed
the
the-
petitioner, my lord.
You are for the petitioner.
Lordship, on few occasions they have taken time, Lordship.
So do you consent or you object?
I consent, Lordship, but they should file on the next day. Before the next.
Counsel for the respondents prepare further 3 weeks time to complete their instructions and file. Mr. Garodia and counsel does not object. Appearing for the petitioner does not object. At least after 3 weeks.
Lordship, may a date be fixed, Lordship.
You make a mention after 3 weeks.
May it please, Your Lordship. Lordship, in item number 42, we have filed an additional affidavit, Your Lordship, and day before yesterday, but it is not on record, Your Lordship.
For the
Record-
petitioner,
Yes, Lordship.
petitioner affidavit. Did it come
Yeah.
on Friday?
No, Lordship. We are led by Ms. D. Goya, Senior Advocate, Your Lordship. We are led by Ms.
If it is the affidavit is not here, you let it be on Friday.
No, Lordship. Record may be called for.
Huh?
Record may be called
No,
for.
no, it may be called for, it may not reach, may not come. We'll have it on Friday.
No, Lordship.
Item
Record may be
42,
called for.
on the request made that the additional affidavit is not on record. Matter be deferred to be listed on Friday. Registry will trace out the additional affidavit
Yes, Lord.
or affidavit in reply.
No, Lordship. Additional affidavit.
Additional affidavit stated to have been filed by the petitioner be brought on record. Be connected to the case report.
Lordship.
List on Friday, names of all counsel.
Take instruction from Ms. D. Goya, Senior Advocate.
Mhm.
I have to take instruction, Lordship, regarding this.
You take instructions, you say the court has passed the order. List on Friday. Names of all counsel be reflected in the court.
May I please, Your Lordship, I beg to mention item number 17 of the daily list with consent from the other side. Let the matter come after 4 weeks.
Item 17,
17, yes. Your Lordship.
17. On behalf of,
Mr. S.S. Roy.
have you informed petitioner?
Yes, we have taken the consent. Your Lordship.
Counsel for responded for 3 weeks time,
4 weeks.
4 weeks time to file their affidavit,
Affidavit.
counter affidavit. It is submitted, consent of the counsel for the petitioner have also been obtained. It's after 4 weeks.
Most of
May it please, Your Lord. The content of the other side, beg to mention item number 51. Due to obtain certain instructions in the matter, we were unable to communicate with the petitioner.
51.
Lordship, 51, Lordship, the petitioner already accepted the VS scheme and we have already released all the amount, Lordship. So matter become infectious.
But this matter was pertaining to non-payment of area salaries and.
Up to August 2024, we have released those.
Okay,
We'll defer it by 1 week.
Lordship.
On the request made by Mr. Rekha Das for the petitioner, matter stands deferred to be listed after 1 week. Mr. N.J. Gogoi, learned
For response number 3 and 4.
Standing Council, Marketing, State Agriculture Market Report, submits that petition has become infractuous, has already been cleared. Be the designated view the prayer may list after 1 week.
List.
Please, your Lordship, with the consent of the other side, I beg to mention item number 60, Lordship. In this matter, Lordship, we will file an additional affidavit.
60.
Yes, Lordship.
On whose behalf?
Petitioner, Lordship. After 2 weeks, Lordship.
Item 60 on the prayer made on behalf of the council that deferred after 3 weeks.
I'm for AG, Your Lordship. Item
Mr. Boro or Boro again for the comment.
May I please, Lordship, for item number 3, give me some time for after 4 weeks that we should take the steps as per the.
Wait, let the matter be called. Wait for your turn, let the matter be called.
May I
Yeah.
please, your Lordship, I beg to mention item number 7. Only matter may be
Item number?
7.
Yes,
Only matter may be adjourned for the day, madam.
wait,
May I please, your Lordship?
1 to 7 you wait.
May I please, your Lordship? Item number 2, Lordship, adjourned for the day. Matter is all, Lordship. Whether item number 2, Lordship.
Wait. 1 to 7 wait.
May I please, Your Lordship, I beg to mention item number 45. Kindly adjourn for the doctor. Kindly adjourn for the lay. Yes.
Whose behalf you mentioned?
D. Bhuya.
Item 45 on the request made, the prayer of the petitioner stands deferred to be listed after 4 weeks.
Wait, please, your Lordship. Lordship, I beg to mention item number 57 on behalf of R.K. Sharma. The assisting counsel is under bereavements, Lordship.
57.
Yes, your Lordship.
Item 57.
Lordship, the matter may be fixed in 3rd week of June.
On the request made by, on behalf of Mr. R.K. Sharma, matter stands deferred to be listed after 4 weeks.
Pleasure.
Arbitrator, A65, we have issued the notice, man.
Where is the agreement?
Yes, agreement page 65, my lord. Consent chapter 32.
65.
65 the notice. And
Where is the agreement?
agreement page 32, my lord, the relevant clause is there. 6411, middle,
Page number?
32.
Same clause,
Same.
My lord, I should notice this.
Or railway?
Same.
Why notice?
My lord, I should
All
notice.
covered matters.
Possibly, I should notice after 4 weeks.
But in Taiwala, the council existed by Mr. General and Mr. K. Gogoi letters for the railway.
Okay.
For all the respondents,
Possible.
issue notice. This is an application under section 11, Arbitration and Conciliation Act. 1996. Honorable Mr. Gogoi represents all the respondents. There is a way, however, extra copies be furnished within 1 week from today. Matter be listed after return of date.
Congratulations.
Yes,
Lordship, this matter is 19 matters, so we need instructions from the petitioner whether matter is infectious or not.
so it has
Lordship.
become infractuous if you have to get instructed. We'll close it.
Lordship,
So
just
this is a
only
what?
pass
This
over
is a
for the date.
transfer matter.
Lordship,
Transfer matter.
Lordship. Just only for today, Lordship.
All right, Friday, you get it on Friday.
Lordship. Much of
On the request made by the petitioner that the instructions from the request made on on behalf of the council, by the council for the petitioner, that instructions are sought for from the petitioner as to whether the matter needs to be pursued. Matter stands heard still on Friday with the new menu for respondent.
Much obliged.
Friday did today.
Lordship adjourned for 4 weeks. That will take the steps as part of order.
You've not taken steps. Steps not taken.
Not taken.
Council for petitioner is granted 4 weeks time to take steps in terms of the orders passed by the court. Mr. N work by the
1 to 4. 1 to 3,
respondent,
4.
1 to 4.
Obliged, Lord.
May I please your lordship. Lordship, last chance may be given to take steps, lordship.
After 4 weeks time granted, take steps on respondent 5 and 6 in terms of orders passed by the court. Mr. Deborah for
1, 2, and 4.
respondent 1 with
Deeply obliged,
up to 4 weeks.
Please, your lordship. Your lordship, due to some personal difficulty, the council will not be present today at this point. 2 weeks.
Why is it for orders?
Yes, sir. But I'm appealing for respondent number 3 and 6, madam.
Meetings are complete, matter be listed for admission.
But I have not received their reply, madam.
Huh?
I have not received their reply, madam.
File.
It was filed, madam.
Since the council for respondent submits that the reply affidavit to have been filed with the petitioner has not been served, council for petition will ensure service of the reply affidavit filed by them, filed by the petitioner on 28th February 2025. Within 1 week from today, that will be listed after 2 weeks. Mr. SP does for
But for respondent number 3 and 6, madam.
3 and 6.
I'm
with
appearing for respond numbers 1, 2, and 5, Lordship.
1, 2, and 5. Harbor Pujari. Arts.
Your lordship. Lordship, in this case, the affidavit on behalf of the state has been filed. We have filed our reply.
Weeks are complete, Lordship may fix it for admission hearing.
May I just pray for a short date, Lordship? The issue is very small.
What is the issue?
Lordship, the issue is the petitioner had participated in the selection process. And for participating in the selection process, he has submitted a certificate which was issued by the NSNIS, the National Netaji Subhash Institute, for sports. On the date he was selected, and thereafter on the verification of the document, when the documents were verified, he submitted his original mark sheet. Now the marks in the mark sheet and the marks submitted in the certificate issued by the director of the institute did not tally. I had got in fact higher marks than what was given in the certificate.
Council submit that the readings are complete in the minute. Matter be listed for admission.
So may I pray for a date?
July.
In June, Lord.
In June. On
Can it be on 12th of June, Lordship?
12.
With the interim order to continue.
Interim order, pass writing will not.
Obliged, Lord.
Obliged, Lordship.
Your Honor, due to some difficulties, Angus Council, kindly
You
matter
have
may
not
be
taken
adjourned.
steps, will dismiss your matter.
What?
Steps not taken. Take it by Monday.
Monday.
Matter be listed on Monday, enabling the petitioner to take steps. Yes, in terms of the office order. MS Bhattacharya for the respondent.
1 and 2 I may take.
1 and 2.
Yes, sir.
Lordship, on last occasion also petitioner did not appear.
order complied or not?
Lordship, I'm here for formal party. So far, my instruction is concerned, some amount has already been paid. The rest, the ACC will,
Where is the direction of the court?
direction is Lordship will file it page 12, my lord. Relevant portion, page 12, under such circumstances. Speaking order has already been passed by the MDASDC and some amount has already been paid.
Yes. Lordship, rupees 1 lakh. Who is to pay it? AST?
ASDC, my lord.
Lordship, we have paid 1 lakh rupees, 1 lakh, 2,300 rupees to her. And the rest, Lordship, is not paid. What is the amount we paid? Amount is around 8 lakhs rupees. Why have you not paid? Lordship, there is no fund, Lordship. We'll pay it by part-wise, Lordship. This direction of the court is to comply within 60 days. Yes, Lordship. But what were you doing for 60 days? Lordship, her documents were not submitted properly. Have you filed any affidavit explaining that? No, Lordship. Then? Lordship, may kindly grant me some time, I'll file it. How much sometime? Lordship, how much is sometime? 3 weeks, Lordship. You are in contempt of a direction contained in this of this order. Yes, Lordship. You did not pray for extension of time. You did not file a review. And you are sitting over this matter. Lordship, her documents were not submitted properly, but on record. The matter, this contempt has got nothing to do with the petitioner being present or absent. It is between the court and the contemptor. Yes. Notices were issued 1 year back. You're already in contempt. Who is the person responsible? Lordship, kindly grant me some time. I'll bring everything on record. We'll give you 2 weeks. No further.
Lordship, I'm appearing for respondent number 1. He is not the commissioner of transport. His name had been wrongly impeded, Lordship. And so I have received,
Petitioner number 1,
yes, sir.
Robin Kumar.
Yes, he is not the commissioner of transport.
Who is Robin Kumar?
Other department.
So whose behalf are you appearing?
For 1, he has filed Wakalatnama. Since his name is there, he has received notice.
So which department is he working?
Health department.
Then
Right.
why have you not filed an application seeking the for deletion of his name?
Initially, earlier he was commissioner.
Say that. Say that. The directions of the court.
In fact, Lordship, when the writ petition was filed, no copy was served to me. Without serving the copy to me, the petitioner has filed the writ petition. And after the Honorable High Court disposed of the matter, he have a non-compliance with the order, he has filed contempt and made that commissioner as a party respondent. But my name is not reflected in the Lordship order also. And I have checked, no copy was served to me in the writ petition.
So do you have anything to say with this order?
Nothing, Lordship, but to assist my lord, I have received some instruction from the ACC that reflected in order dated 8/2, my lord, that I have already stated to this honorable court.
The directions contained in the order dated to pass in WPT were considered. And dispose of the representation dated 1/12/2020. Stated to have been filed by the petitioner for redressal of it. The managing director ASTC was directed to the grievances passes. If any amount is found to be entitled to the petitioner towards the retirement, retiral benefit of the of our late father-in-law, namely late Surendra Chandrapuch Payon, who was an employee and who was superannuated from the KSTC. Stop the order. The direction was the respondents were directed to comply with the order within a period of 60 days from the date receipt of the certificate copy. Is in the para note in the application. Of 22/5/2020. The respondents are represented by the council by but no affidavit has been filed explaining as to why the director contained in the order does not report the item. Mr. C. Sarma, Council ASTC. Prayer made before the court after 2 weeks' time to take necessary steps to either comply with the order dated so and so, passed in WPC so and so, and to apprise the court as to when the order, when the directions contained in the order dated so and so be applied for, file necessary affidavit to explain why the order has not been complied with. Then the order is responded one. Let the matter be listed after 2 weeks. We are giving you a fixed date.
Lordship may kindly fix the date. They will have to comply.
Based on 16
June, my lord.
16 June.
God bless.
Made legal. We have taken first step, but again neither ID card nor is awaited. May I request any additional senior government advocate, Ma'am Bhattacharya ma'am, to twice we have taken steps, Your Lordship. Initially we have taken
You
steps.
wait for the time. Office note 23/5/2025 reflects that ID card on respondent as sole respondent has not been returned back. Matter be placed before the laws of the court. It's after 2 weeks. You are going ahead. Yes.
My lord, as per office note, my lord, for respondent number 1, service complete, my lord. And respondent number 2, my lord, service is awaited. We may be allowed to take fresh step.
26/5/2025. Service on respondent part is completed. However, notice on respondent still awaited. Counsel for the petitioner seeks liberty to take fresh steps on respondent. Prayer made is allowed is after 4 weeks.
3 weeks, my lord, only. Make it.
3 weeks.
It is from Guwahati.
Enabling him to take fresh steps on respondent 2.
Right.
I registered post
Right.
ID as well as legal court.
This is the review petition, my lord, referred by the state note against the order dated, my lord. (27/11/2020), my lord. There is a dispute regarding, my lord, dice code. So my ground for review, my lord, there's a mismatch of dice code. My lord will find the dice code of petitioner school at page 41. It's a type copy, my lord. School particulars, the above, the dice code 18120416911. This is the dice code of the petitioner school, my lord. For the year 2008-2009. Our contention, we have rejected their claim for publication on the ground that they do not have the dice code for the year 2009 and 10. On that ground, it was rejected, my lord. So for 8-9, they have dice code ending with 16911. And my lord, we come to page 65. This is for the year, my lord, 14-15. 14-15. Here, my lord, dice code is 18120416914. So there are two different dice code, my lord. For the year 2008-9 is ending with 6911, and for the year 13-14 onwards, my lord, it is 16914. So apparently, my lord, it's two different dice code. So, my lord, now there is a report from the, my lord, district authority. My lord, find the report at 105. This is the report from the Sarva Shiksha Abhiyan to the Director of Elementary Education, my lord. With reference to the subject site above, please find and enclose the verification report as per DICE database for favor of your kind information and necessary action. So report is at page 106, my lord. The first column, my lord, against DICE code 1416911 and 6914. So here, my lord, will find serial number 1. The DICE code is 16911. The school name is Mamorjan SSK. It's a SS category is SSK Center. It's under SSA and academic year 2008-9. So in the early report at DICE data at page 41, the same DICE code was allotted to Kawai. But as per the report of the SSA, it was allotted to Mamorjan SSK. My lord. So this fact, while arguing the matter, this fact would not be brought to notice of this honorable court, my lord.
What was the direction?
Direction, my lord, will find the.
What was the finding of the court?
Finding of the court, my lord. May read the finding, my lord.
Yeah.
113, page 113, paragraph 9. Upon hearing the learned counsels for both the parties and on perusal of materials available on record, this court is of the view that the order dated 14/3/2017 passed by the district elementary education officer in the present proceeding is indeed rendered without referring to the report regarding the existence of the school as well as the details of DICE code submitted after inquiry conducted by the officer subordinate to the Director of Elementary Education. There is no dispute on fact that school was granted the benefit of provincial by the order that so and so passed by the Director of Elementary Education. The name of school appears at serial number 37 in the list. This order has not been recalled or modified in respect to the petitioner school. In view of the inquiry conducted by the Sub-Inspector of School, Kadam, and report having forward to the BEO to the Director of Elementary Education, it was incumbent on the Director of Elementary Education to have referred to the inquiry made. There is no dispute that the school concern is in existence and the benefit of provincialization had been granted as far back as 14th May 2013. It is also evident from the inquiry made that for the school has been captured for the year, the DICE code for 2006, 7, 7, 8, 8, 9, 9, 10, 10, 11, 11, 12, 12, 13, except for the year 2019, 10, the school satisfies the requirement of having DICE code since the year 2006, 7. All these verifications were stated to have been conducted prior to grant the benefit of provincialization to the petitioner school as far as 14 May 2013. In view of the discussion above and in terms of the similar orders passed by this court, the impugn order dated 14/3/2017 passed by the respondent number 3 set aside, and the matter is remanded back to the Director of Education to reconsider the representation of the petitioner already on record, afresh by relying on the relevant documents. The Director of Elementary Education will pass fresh order upon on the representation of the petitioner seeking conferment of the benefit of provincialization of the school in terms of order date so and so already granted by the government, wherein the name of the school APS at serial number 37. Since the existence of the school is not disputed, the information captured in the DICE code for the year 6-7 to 12-13, except for the year 9-10. Therefore, the non-availability of the DICE code for the year 9-10 reasons for which cannot be attributed to the petitioner school cannot be constituted to be a default on part of the petitioner. disentitling the petitioner school from the benefit provisional order already made by the government. So this was the direction, my lord.
Now, coming to para 9,
Yes, my lord.
where it has been held that dice code for so-and-so year have been captured
Yes, my lord.
from 6/7 to 12/13.
Yes, my lord.
Where, from which document? Is it
My lord,
evident?
in that regard, there is a report, my lord. In fact, that report has already been referred in page 6 also, my lord. The communication by the district elementary education officer.
Where is that report?
Yes, my lord. It's a order, my lord, 82, my lord. Report is at page 81 and the order is at page 82, my lord.
82.
82, my lord.
Yes.
A school named by Mamorjan SSK under Lakhimpur Education Block exists in the DICE database of 2008-9 in the office of the undersigned against the school code 16911. The name of the school was initialized in DICE as Mamorjan SSK. Whereas subsequently the school authorities has submitted the application in the office of the mission director SSA Assam praying the correction of the school name in DICE as Kawimari Nopomo LPS instead of Mamorjan SSK. Whereas the school has been verified along with the other relevant documents by the BEO Lakhimpur, so as per so and so, the name of the school is found as Kawimari Nopomo LPS. Under the above circumstances and in persons of the letter from the executive director SSA Assam, so and so dated so and so, the name of the school has been corrected in DICE as Kawimari Nopomo LPS instead of Mamorjan. So actually, Malad, the school was in the DICE code was allotted to Mamorjan SSK. Since for the particular period 9-10, there is no DICE code for this petitioner school, Malad. It was corrected, Malad. It is not the case that they have the.
No, there is an observation by the court.
Yes, my lord.
That dice code has been captured for this year. And it, from the inquiry made. Where
Yes.
is that inquiry report? Para 9 of the judgment.
Yes, it is page 81. The very before the order, my lord, page 81, my lord. May I read, my lord?
Yeah.
With reference to the subject cited of as per your order, your office letter number so and so dated so and so, Sub-Inspector of Schools Kadam Circle under Lakhimpur Education Book and entrusted to verify all the documents of Kawimari Nopomo LP School, including the record of Mamorjan SSK regarding the DICE code number 16911, which is claimed by Kawimari Nopomo LP School instead of Mamorjan SSK. In this regard, Sub-Inspector of Schools Kadam has submitted the detailed report and from which following conclusions may be accepted. There is no existence of Mamorjan SSK. The habitation where Mamorjan SSK existed is also now under River Subonsiri. Moreover, such type of SSK is already closed down by SSA. Kawimari Nopomo LP School has submitted the DICE for the academic session 2006-7, 7-8, 8-9, 8-9, 10-11, 11-12, 12-13, except the academic year 9-10 bearing DICE code 6911. The Kawimari Nopomo LP School was initialized in the year 2006-7, duly signed by the then ADC and DMC contains the same code as 16911 in the list of recognized venture school initialization. So finally, it can be said that the school code 16911 was initialized in 2006-7 by the then ADC and DMC and allowed to Kawimari Nopomo LP School for same academic year as the authority concerned. And moreover, no SSK is running presently. Kawimari Nopomo LP School may claim the DICE code of so-and-so instead of Mamorjan SSK, which has no existence and hence the name can be corrected as DICE database of Kawimari Nopomo LP School instead of Mamorjan. Here also finding is same, Malad. They have the DICE code for a particular year, Malad, but for the required year 2009-10, they don't have the DICE code. So the district authority has corrected their DICE data in the from the school SSK center in the name of Mamorjan SSK. Malad.
So, but this is your report.
Yes, Malad.
This is the report.
Yes, Malad.
You're not withdrawing this report. This is what is written in the order that this report has not been interfered with.
Yes, but the thing is that, my lord, for the previous year, from page 106, what is discernible from page 106, my lord?
This document was not placed before the court.
Yes, my lord, that page 106 was not there, my lord. Page 106, where my lord will find For 8-9, the dice code is 16911.
This is a part of what document?
This is a part of the affidavit, my lord, but it was not referred to. This is an affidavit,
on record?
my lord.
It was on record.
101. It was in record, my lord. 101, page 101. This is the affidavit filed by the Director of Elementary Education, my lord. Though it was on record, my lord, it was not referred to, my lord. Here it is seen that, my lord, for the year 2008-9 also, the petitioner school has the same dice code that has given to the Mamamorjan SSK, my lord.
So what is the meaning? Show us that report again.
Yes, my lord. Page 81.
No. 106.
Yes, page 10.
106.
106. The first row, my lord. District Lakhimpur. The dice code is so 16911. School name is Mamorjan SSK. SSK Center, category is SSK Center. It is under the management of SSA. And for the academic year 2008-9. So
And where is the report which finds mentioned in para 9?
Para 9, my lord, page 81 report.
81.
Yes, my lord.
Now you tell us that
Yes.
6, 7, 7, 8.
Yes, my lord.
There is no defect.
There is no defect.
8, 9, according to you now, there is a defect.
Yes, my lord. 8-9, there is a defect, my lord.
Now,
Page 41.
If 6, 7 and 7, 8, there was a dice code. Is it possible that 8, 9, there can be no dice code for the school?
Pardon,
Or
my lord.
if 6, 7, 7, 8,
Yes.
you have allotted a dice number. For 8, 9, is it possible that they'll have to again review their dice number, or
Normally, it is not possible, my lord. That is why some doubt.
we are asking you is, supposing the school is given a dice number on 6, 7. Now, for the dice number to continue for 7 and 8,
Yes.
what is the procedure?
They have to fill up the formula, nothing. From the said data, my lord, they just entered a new.
So, is there a possibility that when the school is in existence,
yes,
and fulfilling all the requirements, yet for some reason dice number allotted on 6 and 7 may not be continued for 7 and 8 unless the school is closed or non-functional?
Normally, it won't happen, my lord.
Normally won't happen.
Yes, my lord.
So now in your report at page 81, you see 6, 7, 7, 8 you have given.
Yes, my lord.
8, 9, somehow the wrong number was attributed.
Yes.
So whose fault is it? It can't be their fault. They already have their dice number of 6, 7, 7, 8. There is no occasion for them to misuse somebody else's dice number and project it to be their own. They have their dice number. Unless you say that no, 6, 7, 7, 8 school was closed. So there is a gap. Again on 10, 11 or 11, 12 they started. There is no finding like that.
There is no regarding existence. There is no contradictory finding, my lord. Only
So
finding is that.
what is the difficulty that why are you seeking the review?
My lord,
assuming this particular document was not taken on record.
Yes.
How does it eventually change the conclusion in the judge?
The only reason is, my lord, for the year 2008-9 also, the school, though in the report it has been stated that the dice code is 616911, but practically the said dice code was allotted to the Mamorjan SSK, my lord.
This allotment is to be done by the department.
Yes.
Now, unless you are saying that the number which was allotted is for 6, 7, 7, 8 was not followed in 8, 9. There is no material to say that 8, 9, this number which was there in the school got cancelled or was given to some other school.
No.
No such thing. So insofar as their school is concerned, assuming this wrong dice number is not allotted to them, then for 8, 9, there is no dice number. And again for 10, 12 onwards, there is a dice number. So if they have the dice number which is accepted for earlier year and subsequent year, for a particular set of years if it is not there, then what consequences follow? Can the salaries be stopped? Somebody has, you will have to attribute some fault or defect to school that because they did not submit in time or they submitted wrong papers or whatever it may be. No such finding is there.
Apparently, no such finding. The only requirement under the earlier Act to have the dice code for the year 2009 and 10. That was the requirement, and that was not there. That is why it was, though provincialized, school was provincialized, but the benefit was rejected on that ground only. For 9 and 10, it was not there.
They must apply for every year. Nah?
Yes, my lord.
There is a process for application.
Yes, my lord. Process.
In the application for 8, 9 or for that year which you say was wrongly attributed, what is written in their application?
That, my lord, today I don't have that application, my lord. But normally, my lord, the correction made in this case, my lord, it is not actually allowed to do the name of dice code of one school to transfer to the other school.
Okay. That is why I want to say that their application is perhaps not before you to say that they had wrongly quoted the dice number.
Yes, my lord.
So somehow the wrong number got attributed to them. And these are all routine things. For every year, you file an application, goes, record. For 2 years, it is correct. For the third year, some wrong number. There. Now, how do you attribute fault to these? To deny them their salary. Scheme of provision. That's the question.
Yes.
And your report, the finding in para 9 is on the basis of a report.
Yes, yes.
That report also, it is recorded in the order that the report has also not been recalled. Yes. That's all.
That's all. That is the only ground, my lord. Because subsequent year after provincialization,
Assuming that you are correct, that you are correct from the document that yes, for 8, 9 number was not there. How does it affect the conclusion? Does it affect the conclusion?
Our understanding is that, my lord, the existence of the school.
Conclusion in para 11.
Yes. Yes.
Where we say that non-availability of number for 9, 10. Now you are saying even 8, 9 is wrong.
Yes.
So you have to give reasons why for 2 years, for 1 year number was not there, for another year the number
mismatch.
If you say the school was not in existence and it continued, it may so happen. Where is the school situated?
Not looking for my.
It's for area.
No, yes, nearby River Brahmaputra.
So nearby river Brahmaputra for 2 years may have been washed away part of it has been washed away.
Totally missing community area, 100% missing community area.
That evidence must be laid before the court by the department that for these 2 years there is no evidence of there is no material to suggest this school was in existence. Not here.
That is my submission, my lord. Our understanding is that, my lord, for particular year and the school did not have the dice code, and so this is the requirement under the particular statute at that time.
See, para 11.
I have seen, my lord.
Para 11, the conclusion is that if from 6, 7 to 12, 13, dice code is there except for 9 and 10. That will not debar them. That is the finding. Now you want to say that in addition to 9 and 10, 8 and 9 also, some other number was attributed. But the conclusion is of the court is that this is on the basis of a report, and that report has not been recalled to say that it is an incorrect report. So how will a review, assuming we review and we add that all right for 8 and 9 also it was wrongly shown, how does it change the conclusion? Unless you say that we have now evidence or evidence was available then, we could not place it before the court for whatever reason, that the school was not in existence.
Apparently, my lord, that is not the case of the department, my lord.
So we close it. Yes, Mr. Bora?
Yes, fine. My lord, review is filed only because of save the contempt, my lord. Contempt proceeding is drawn up, thereby they filed the review, my lord. And last order of your lordship order is very clear, my lord. My lord, if now would permit me, my lord. Last.
You find out from the records if there is something, some more material available, if you think is necessary for the court to take opinion on fact, only on facts.
Yes, ma'am.
And that, my lord, report is made, my lord, on the basis of earlier High Court Honorable Court's order.
We'll do that, but we are just giving them, say, 2 weeks further time. If they have anything, we'll consider. We'll give you an opportunity of hearing. Otherwise, we'll close it.
I already filed it. Affidavit in opposition already filed.
Huh?
I was already filed affidavit in opposition.
What affidavit? It is a review.
Review.
Why affidavit is necessary?
My lord.
You have already filed, you are the petitioner.
My lord.
So why affidavit is necessary? Heard Mr. N.J. Katonia, counsel for the petitioner, Mr. N. Boral, counsel appearing for the petitioner. The petitioner, the review petitioner is before the court in review of the order, judgment and order or order dated with the whereby the writ petition was allowed. Order dated with the conclusion arrived at by the court by the order dated so and so since the existence of the school is not disputed, and the information captured in the DICE code DIS code for the years 2006-2007 to 2012-2013, except for the year 2009-10. There is no event. There is therefore non-availability of DICE code for the year 2009-10 cannot be non-availability of DICE code for 2009-10 for the school for reasons which are not attributed to the school cannot be construed to be a default on the part of the petitioner's school is entitling the petitioner's school for the benefit of provincialization order made by the government. In the present review petition, the review is sought for on the ground that in addition to the year 2009-10, for which the DICE code is not available, for the year 8 and 9, for the academic year 8 and 9 also, the DICE code shown to have been allotted to the school is 1812041. Review petitioner, counsel for the review petitioner therefore submits that besides the year 2009-10 for which no DICE code was available, even for the academic year 2008 and 9, the DICE code shown to be allotted to the petitioners is different from the DICE code. It's been shown to be allotted to the school for the previous and the subsequent years. This information was available in an affidavit filed by the director before the writ petition, which however could not be referred to by the council appearing for the review petition at the stage of hearing. The review counsel for the review petitioner, however, clearly submits that the conclusion arrived at by the court as reflected in para 11, 9 and 11, based on the report. Conducted by the sub-inspector of school Contempt, and which was forwarded to the higher authorities. And the report has not yet been reported. So, he therefore submits that the matter be listed after 3 weeks, permitting him to address the court on the basis of information of the department as to how there was a mismatch in the dice code allotted to the school for the year 2008 and 9. Mr. N. Bora, counsel for the petitioner of the party, I will submit that there is no infirmity in the order passed. The conclusion arrived at by the court is on the basis of the reports of the inquiry conducted by the sub-inspector of the school, and it was duly accepted by the higher authorities, and this report still stands. The same has not yet been reported. The review petition has only been filed to court for the contempt proceedings already initiated against review. Therefore, submit the review petition as dismissed. Having heard counsel for the parties, in view of the submissions made by the review counsel for review petitioner, we may be appropriate to grant further 2 weeks time. Further 2 weeks time.
Fixed date, man.
18 June.
March.
Lordship, here in this case, Lordship, the process is going on, Lordship. I have to file a response, Lordship. Can you fix the matter after 5 days, Lordship? Can you give me the 5 days, Lordship? I will.
Mr. K.R. Patgiri for the petitioner, Mr. A.K. Goswami for the counsel for respondent 1. Mr. Goswami submit the matter be taken up after 1 week. They are made not objected to by the counsel for the petitioner list after 1 week.
Outline.
May I please your lordship? An interlocutory application in contempt is filed by the contempt petitioner for implement of the.
You are appearing for whom?
Lordship, I'm appearing on correspondent number 1 and 2.
Respondent
On
1.
behalf of the
So you are including whom?
Finance Department,
Finance.
Commissioner and Secretary. Hello. Respondent, yes, respondent number 3, contempt number.
Yes. Mr. Nayak, are you representing Finance Department also? Heard? Mr.
S.K. Das.
S.K. Das, counsel for the petitioner. This IA has been filed by the petitioner as alleging willful disobedience of the directions contained in the order dated passed in the petition. So it is the submission of the counsel to the against petitioner that
for implementing the
order has not yet been complied, and the finance department is required to be added to the party. Where they responded in the petition. Was final?
My lord.
Huh?
My lord. Contempt page number 19, my lord.
It is submitted that the finance department was added as party number so and so in the writ petition so and so. However, in the present contempt petition, contempt petition number 329/24, finance department was not added as the party by oversight. So we therefore submits that direction be passed in the IA permitting the petitioner to array for arraying the finance department as the party respondent in contempt petition number 12. If the commissioner and secretary in his personal capacity as respondent. Better. Prayer made is not
It's being a contempt case, not. Let my friend, there is a person holding the post.
who is the person holding?
Probably Narlikar is there, Jayant Narlikar.
So he is arrayed, given the name.
Not police notice.
Okay. In view of the submissions made, let notice issue returnable 2 weeks. Mr.
R. Sahana, I'm appearing on behalf of Dina.
R.
R. Sahana.
Sahan
Yes.
appears on behalf of Mr.
Dina.
Dina for respondent number 1. Who's for number 2?
For respondent number 1 and 2.
Yes, who's for respondent 2?
Dina, my lord.
For respondent number 1 and 2.
Only for 1.
For 1 and 2, both.
1 and 2 he is appearing.
1 and steps on respondent number 3. That is completely within 1 week. Is trustees of the permitted. Matter steps. Matter is made returnable after 3 weeks. It's according.
Pledge.
May I please your lordship? Your lordship, advocate DJ Sharma is having some personal difficulties today, so we are praying for adjournment in this matter for today.
We are issuing notice in your IA, heard counsel for the party. Issue notice returnable 4 weeks. Steps on the of the party. Registered for city within 1 week from today. Mr. R. Sahan appears for respondent 1.
Respondent number 2.
1 and
Only 2.
only 2. Already. Yes.
Proposal. My lord, I've got a latest instruction, my lord. Yesterday, proposal has been mooted to the government, my lord, regarding non-payment of arrear salary of 59,000, my lord.
59,000 and all.
This will be after some time, my lord, after 4 weeks.
Yes, Mr.
Yes, sir.
Mr. T. Bodo, Mr. T. Boyle, and that's council appearing on the proposal dated 2025. See from the health director of health services. The has been forwarded from the director of health services to the Department of Health and Family Welfare for sanction of arrear salary / VA respect of the petitioner for an amount of rupees 59,861. Submits to the matter be listed after 3 weeks, by which time the will be sanctioned and likely to be sanctioned and released to the petition.
After 4 weeks, man. We will have to move the finance also, but.
All right, 4 weeks.
Right.
After 4 weeks.
Right.
Whether the IA is for changing the array of parties, the respondents in the office of the respondents, whether the incumbents have been changed. There to complete the newly appointed incumbents, the IA has been filed. The changes are indicated in paragraph 3 at page 4 of the IA. These there have been some promotions, some transfers, and therefore this change has come.
So you want to implement?
The parties mentioned at paragraph 3, 1, 2, 3, and 4. In fact, they should be the only parties in the contempt petition now, because the earlier incumbents have either retired or transferred out.
Holding the same offices.
Yes, some of them are same, Lord, because of promotions, their positions have changed. Just for example, the person named at serial 1, he was previously respondent number 3, but there has been change in his portfolio, so he has become, he will become number 1.
In your contempt petition, you have as many as how many?
There were
7 respondents.
There were 7. But out of these, Milords, if your Lordship will kindly see the paragraph 3 of the IA, the person at serial number 1, he was previously at respondent number 3. But now he has been appointed in this position. So there is a change. Respondent number 2 is a new incumbent. And respondent number 3 indicated here, he was previously respondent number 4 in the original contempt petition.
What about respondent 1 in the contempt petition?
Well, he is no longer there. He has been transferred out to some other department. So I'm sorry, Milord, the respondent number 1 has retired. Mr. Prasad.
So you want his name to be deleted or?
Yes. In fact, Milord, if these parties are replaced, Milord, that will be the new array of party. So like the respondent number 2 has been transferred. 3 has been.
When the order was passed.
Then they were there.
Then they were there.
Then they were there. So additionally, Milord, these 4 persons may be implemented. In fact, if the positions, inter-se positions are considered, Milord, then respond now.
No, is there any other person other than respondent 7? Sorry, respondent 1 to 7.
Yes.
Who you want to be arrayed as party?
These are, yes, there are 4 persons, Milord. This is indicated in the IA.
We are not asking for interchange. New person.
New person, yes, that will be. Yes, the number, Mr. Vinay Gupta, he will be the new person.
And perhaps number 2.
And number two will be new person, yes. Number 2 and 4, they will be the new persons.
So since the others are already there,
but Milord, to effect the notice, Milord, their addresses will also have to be changed because the portfolio has been changed now. That is the reason. As for example,
your submission is that in place of respondents 1 to 7.
If these parties are brought, Milord, then it will suffice.
Okay. Very good. that we'll better, then you we issue notice here or
In the IA.
uh,
In any case, my lord, the notice will have to be issued to them after they are implicated in the contempt petition.
this IA has been filed, contempt petition numbers going on, seeking implement of the following respondents. There are three tickets. Topic is submitted. That if the contempt petition numbers going to, there were as many as 7 respondents. So some of the respondents superannuated during the pendency of the contempt petition, and some have been redesignated. So, the senior counsel, hearing to the contempt petitioner, therefore submit that the array of parties, respect to the respondent, may be permitted to be rearranged, and instead of the earlier respondent 1 to 7, the present incumbents as reflected in para 3 of the IA be permitted to be arrayed as party respondents. So, considering the submission made by the petition as well as upon perusal of the government made it the IA, the IA stands allowed. This court is of the view that at this stage, without issuing notice on the person who are sought to be completed and respondents in the contempt petition, the IA stands allowed. Stop. The court is of the view that the persons will be impleaded in the contempt petition upon issuance of fresh notice in the contempt petition, they will be entitled to file their objections or affidavits. No prejudice will be caused to them. That view of the matter, the IA stands allowed. So and so, 4 names, as in para 3, are arrayed as party respondents in place of respondents 1 to 7. So the names of respondents 1 to 7 stand deleted, and in its place, the respondent in its place is 1, 2, 3, 4 in para 3 of the IA are directed to be arrayed as respondents. So petitioner will file amended course title within 2 weeks from today. IA accordingly stands allowed disposed of. In the contempt petition, you write in view of the order passed today in IA number 12, the present respondent 1 to 7 names stand deleted from the array of respondents in the contempt petition, and in their place, these 1, 2, 3, 4 are arrayed as respondents. So the petitioner will file amended post title that effect to the rates within 2 weeks. Matter be listed thereafter.
Well, that we may also be permitted to issue notice on the.
You file the amended post title first, because somewhere along the line it may lead to some confusion. Get the amended post title, will pass out
after 2 weeks.
After. You want 1 week, we can give you 1 week.
Yes, one. That will do.
I got 2 weeks from there, 1 week. Matter be listed after the amended post title is filed. Be listed after 1 week after filing of the amended post title.
Published.
My present lordship. This is a matter pertaining to wherein the petitioner pertaining to promotion, wherein the petitioner was claiming for promotion to the post of junior assistant in the forest department. He had joined the department in 1989 as a master roll worker, subsequently regularized in 2001. A person who was appointed in 2004 was promoted. Now, lordship, the stand of the department is that she has submitted an application wherein she has said that I am not interested in promotion, and therefore promotion may not be granted to me. Lordship will kindly take up the affidavit for a moment.
What is your prayer in the
Lordship, my prayer is for granting me promotion with effect from the date my junior was promoted. That is the only prayer in the promotion.
Affidavit?
Affidavit, your lordship takes up page 60, starts from page 60. I'm sorry, lordship, 59. Page 59, lordship.
Page 43. Affidavit in opposition.
Affidavit in opposition by respondent number 2.
Right. Yeah.
Lordship will kindly take note of one aspect. Page 59, then the deponent states herein, I, Sri so-and-so, aged about so-and-so, do hereby solemnly affirm and declares as follows, that the deponent is presently serving as Principal Chief Conservator of Forest and Head of Forest Force. Now your lordship will kindly come to the signature at page 61. The deponent herein is the Divisional Forest Officer, not Kamrup Division.
That's a typographical error, Your Lordship.
That
That's a typographical error. It should have been
Presently
DFO, Your
serving as
Lordship.
Principal Chief Conservator.
Yes, he is a DFO. This deponent DFO. The typographical error.
Then not the affidavit itself is faulty because it is filed by the respondent number 2. Respondent number 2 is the Principal Chief Conservator of Forest and Head of Forest Force. He has not filed this affidavit then how can the DFO file an affidavit on behalf of the respondent number 2 without there being any authorization as such?
Why do you say DFO?
Page 60.
The signature is
61.
Page 61.
The seal and signature. Page 61.
It should have been respond number 4. Error is respond number 2, and the error is in PCCF. The signature, the deponent is a DFO. It should have been respond number 4, Your Lordship. There's a typographical error in this affidavit, Your Lordship.
All right. Besides that, what?
Lordship. Besides that, their only ground of contention is this letter, page 63. The typed copy is at page 62, Lordship. May I read it? To the Principal Chief Conservator of Forest and Head of Forest Force, application in connection with promotion. With due respect, it is humbly submitted that I am working as Day Chokidar in the office of Nalbari Divisional Forest Office under North Kamrup Forest Division. From reliable,
You were transferred and promoted.
No, Lordship, I have not been promoted. They rely upon this letter to say that I had submitted this letter saying that I forgo my promotion, and accordingly promotion was not granted. My contention is, Lordship, I have specifically stated in my affidavit in reply as well. I had submitted a representation subsequently. This was forwarded by the same divisional forest officer, stating that I am admittedly junior to the person promoted. That your lordship will find at page 38.
No. What do you say regarding this letter?
Lordship, regarding this letter, I have made categorical statements that this letter was never submitted by me. And we have also submitted an FIR in this regard. Upon gathering knowledge that they have brought this letter, we have also submitted an FIR that is at page 39. And it has been my categorical stand all along that this letter was never submitted. And even if assuming...
What is the status of the investigation?
Status of the investigation...
Is this your signature or not? 63.
63 is not my signature. That also I have stated in my FIR at page 41. Page 41, if your lordship kindly says. Third line. May I read it? Page 41, lordship.
Yeah.
My FIR, third line. Be it mentioned herein that I have never submitted any application before any officer of the Department of Forest, that I do not want promotion. And as such, it is crystal clear that any application submitted by PCCF or any other authority stating that promotion is not necessary for and on behalf of me is a false document. And the said document is manufactured with a view to cheat me and deprive me from my promotion. And the said act was done with malafide intention so and so. Your lordship will kindly see thereafter. Be it mentioned herein that the sample signature of mine in Assamese as well as in English are annexed to it. I have reasonable suspicion that the accused one was early or any other fourth grade employee who are junior in my service and who are promoted to the post of junior assistant in the year 2016 had done the said illegal act in cooperation with the employees of the office of Contempt. Now, lordship, the background of this case is clear.
What do you say regarding this letter?
Lordship, this is the application which the petitioner submitted before the PCCF. On basis of this promotion was
They
cancelled.
denied it.
They've denied it now. They've denied this. The application was 2015. Application in 2015.
No, they say that they never submitted.
They never submitted,
of
but this
denying it.
application was given to us, Your Lordship. That's why we got this is signature.
They say that this is forged or not submitted by
But they have already raised an FIR against it, Your Lordship.
which they have.
Which they have. So let them bring the series of FIR because as per our instruction, only because of this.
Is this the only document you have to justify that? Is there no other document in your records to say whether it was submitted by her or not by her?
Because, Your Lordship, this document also produce, because the denial and promotion was basis of this, Your Lord. Because he said that since I have a domestic problem, I don't need the promotion. This is the reason we have given a promotion.
Not domestic problem. He said something about her mother.
My mother is physically handicapped and I have some domestic issues, Your Lordship.
Who has received this letter? Page number 63.
This was
It appears that it was received by one of us, who is the main accused in the affair, the dealing assistant of the office of the PCC. Signature source
And you
AFAJ.
see, there is a difference between the translation of. In the original, there is no date of submission of the.
the 12/10/2015 we have received.
Look into the page number 63. There is no date.
There is no date.
And you have in the translation you have said registered on so and so date so and so.
Because this is a receiving date, Your Lordship.
That's right.
Yes. That's a receiving date.
This is not the date on which
Is
cannot be presumed.
Yes, we received it on 12/10/2015. There is no date from the application which was submitted before us.
So in view of this or view of this letter, is the authority required to pass an order saying that we are rejecting his claim for promotion in view of the representative?
In view of this letter, Lordship,
Promotion is as per the rules, as per the procedure. So there will be a TPC or some committee. Was it placed before the committee that one of the candidate has declined to accept the promotion? The orders were passed on that. Your affidavit does not say anything.
doesn't say, we were just issuing on this a lot. If we don't have not detailed file in detail affidavit in this regard, we just
Do
please
you require an invitation to file?
no, Lordship, because if we have any category in this regard, we'll file a detailed affidavit.
Stopping you from filing a detailed affidavit for the past 3 years?
Because we were asked to bring the produce the record. We produced the record, and from the record, this letter was given to the court. The court said bring it on record, so we brought it on record, Your Lordship.
When was the order passed?
Order as well. That was on 14/8/2023.
There is no order saying that records are to be produced.
Lordship, on 14/8/23, the respondents submitted that records are available with them. Accordingly, they were well and 14/8/23.
What is the procedure for promotion under the rules?
The seniority, Your
rules?
Lordship. Seniority come merit, Your Lordship.
Where is the rules? What rules?
That will kindly say. The rules itself,
What rules? Which rules? What rules?
Lordship, the post of junior assistant, the post to which we are seeking promotion, that is not again notified under the Assam Junior Forest Service Rules 2005. All the other posts are there. But this post of junior assistant, so which method they are applying, that also is obscure.
First, you raise your claim that it is covered under so-and-so rules, then this is the post.
Lordship, the post is of junior assistant.
Then
Post
if
is of
it
junior
must be a part of the cadre.
should have been a part of the cadre.
Oh.
But unfortunately, the rules of 2005, the post of chowkidar is there, all other posts are there. But the post of junior assistant is again missing. The procedure, as
Then
per
on
my
what basis are you
the
claiming?
procedure as per my instruction is they follow seniority cum merit. And seniority page 38, they have admitted that I am senior. There, the letter of the divisional forest officer, North Kamrup Division, page 38.
See, if you want an order from the court, you have to show that you are entitled to get this order in view of the rules or the procedure we shall follow. So you show us what rules are followed, what procedures are followed.
The rules are silent as regards promotion of junior assistant.
You at least tell us that there was a TPC held, TPC had recommended and so people. Where is that?
Your Lordship.
You are asking, in your prayer, you have sought for a direction to the TPC.
Lordship.
You tell us that in view of the letter alleged to have been submitted by you,
Lordship.
somebody else was considered and was given promoted.
No, Lordship. This was only informed to us by the dealing assistant wherein we had prepared a representation. That representation was again forwarded at page 38, saying that my case should be considered for promotion and I am senior, page 38. Thereafter, Lordship, nothing had transpired. And the promotion orders were issued previous. Promotion order, your Lordship will find at page 33. There is no mention that I had submitted any application foregoing my promotion. Page 33 is the
In
promotion.
the order, obviously, it will not be there. It must be there in the record.
And page 38, Lordship, the forwarding of my representation. Therein also the authorities admit, your Lordship may kindly take up page 38 for a moment.
Yes.
Page 38. May I read it, Lordship? Dated 25/1/2019. With reference to the above, I have the honor to forward here with an application submitted by the Srimati So-and-so, that is the petitioner herein, of this division and prayed to issue promotion to the rank of junior assistant. In this connection, I would like to inform you that Srimati So-and-so has joined this department on 30/3/2001 as Chokidar. And after getting appointment by the order number so-and-so, thereafter she is working sincerely till date without promotion. It is worth mentioning that one Salamat Ali, the Lordship kindly see, who was appointed by the office order dated so-and-so 19/2/2004, who is junior to Srimati Charala Kakuti Boishkar, that is the petitioner, got promotion to the rank of junior assistant by the office order dated so-and-so. Therefore, I request your honor kindly to consider the prayer of the applicant. Now, this is by the respondent number 4. And this respondent number 4 has now sworn in affidavit, which my learned friend says is a typographical error, by the respondent number 2, wherein now the stand is an application was submitted. But the respondent number 4, this letter, he categorically states that it was forwarded and she is working since then. And the person who was promoted is an admitted junior to the petitioner.
So where are the rules to say that it is seniority cum merit?
The rules are silent as because only the promotional order states that in persons to so-and-so and without prejudice to their inter-se seniority, the following persons are promoted.
We can close it with a direction to the PCCF to consider everything and pass appropriate orders, but we can't issue direction to consider you for promotion because the rules are not clear.
A lot of people grant me a week's time then if I can take instructions on that regard.
Please next week at the request of the council for the
First one.
Oblige that. May I please, Your Lordship? Our matter relates to overstay in service, and that is only seen after retirement. And the whole thing was traced out as the whole thing was done as because earlier in the year 1970 or 74.
You were appointed as what? Gram Sevak?
Gram Sevak, yes.
In the post office? No.
Hello?
What is that? In which department? PNRD?
Yes, PNRD.
Is it what grade? What post is it?
Grade 3, madam.
Grade 3.
Yes. And earlier what happened, the birth certificate was not there. So the matriculation certificate, only age was there. So when the department entered his date of birth, some mistake may be there, for which he overstayed 3 years, which was traced out only after his retirement in the year 2019. Ma'am. May I, please, Lordship, kindly come to page, Annexure 1, page 11. And as per this letter, the BDO asked me to hand over the charge, and thereafter, as per Annexure 2, I handed over the charge.
Where is the where is the recovery order?
The page Annexure 6, page 19. An amount of rupees 18,37,500 for this excess 3 years. So this amount has been already actually deposited by me, because at that time I was in a, my lord, great need of money after my retirement. In the year 2019, my daughter was also had to be married. So this amount was actually deposited. Thereafter, in the year 2021, this person died. And the present petitioner is the wife. The only thing is that the date of birth was wrongly inserted.
By which order the account is got to be recovered? Page 19.
Yes, ma'am.
19 appears to be a certificate.
Then another letter is there, my lord, page 20. It was forwarded by the BDO to the director, madam, joint director, PNRD. Specific order, I don't.
By which order the deduction was already made?
Yes, madam. I don't have the exact, my lord, order.
When was the deduction made?
In the year 2020, madam.
In the year
2020.
20.
Yes.
Any affidavit filed?
Not yet, Your Lordship. We will have to file. During his lifetime, employee's lifetime, it was recovered. He never challenged it. Now his wife is coming up.
But the situation goes like that, my lord. During his lifetime in the year 2019, after his retirement, whole thing was there. At that time, he had to giving up his one daughter to marriage, and another two daughters were there. And the constant pressure of the department was also there, saying that if you don't give this money, then we cannot allow you the pension. So with that effect only, the amount was recovered. And thereafter, his physical and mental condition was not there. In fact, my lord, during his lifetime, he met me in the year 2021, prior to his death. But due to his ill health, he could not come. And in the year 2021, he died.
Well, you file your affidavit.
Yes,
let
sir.
us see. But traffic mercy principle is
Yes, sir.
grade 3.
Yes.
Why
But,
it was deducted in violation of law?
file affidavit, Your Lordship.
So you file affidavit, but you also explain why the amount was
Yes.
deducted in violation of the law laid down by the.
Yes.
It becomes the law from the date it is delivered.
Yes.
Bound to be complied with.
Thing is that in his lifetime, he never
He may
hesitated.
not have challenged, but that doesn't give you a handle to commit an action which is contrary to law.
That is correct.
He may not have challenged. Law is meant to be complied. It cannot be understood that you will not comply until somebody challenges. So
Here also from his pleadings, it is found that a undertaking was also given by the his employer.
where the law says that don't deduct grade 3 and 4. If you cannot attribute it,
Yes,
if you have undertaken an inquiry and found that yes, he is responsible for
That is correct.
falsification of documents, etc., then you can do it.
Yes.
But that inquiry has to be there.
Yes. Weeks time may be given.
Right. Mr. Khan, more additional with that other time prayer made by Mr. Moore is how state required to have it state why the amount came, the circumstances under which the amount came to be deducted from it, and whether in the inquiry prior to the amount being deducted was undertaken by the department.
All right.
Lord Pujari, you are appearing
It was for respondent 4, my lord.
for respondent.
May I pray for an date, my lord?
After the
Any date, my lord? So,
18, like 18th of June.
Okay.
18.
May I please, the lordship? My lordship, kindly peruse the order dated, my lordship, 25/9/2024, my lordship. Respondent taken time file affidavit, the Honorable High Court observed that the writ petition will be taken up for disposal on the basis of material already available on record. There are subsequently, my lord, on 30/10/2024, my lordship, within my lordship. In view of the order dated 25/9/2024 passed in the preceding, making of the no further time will be granted for filing affidavit. The prayer made by Mrs. Datta cannot be accepted. Therefore, the right of the respondent to file affidavit is hereby struck off, my lord. So my case is that, my lord. My lord, my case is that as per order of the Honorable High Court, my lordship, page 16 may be seen. Page 16.
16.
Yes, my lord. This is the judgment of the Honorable High Court, WPC 8618 of 2018, my lordship. I was terminated from service after Honorable High Court by this order directed for, my lordship, last paragraph may be seen. Resultantly, that the impugn order having been held to be stigmatic, the court has no hesitation in setting aside and questioning the order under such and such, dated 24/1/2018. Resultantly, the petitioner is found entitled to be reinstated in service. According to the respondent number 1, that is the Commissioner, Panchayat and Rural Development Department, is directed to pass consequential orders within a period of 4 weeks. After that, my lordship, the page 20 may be seen. Page 20. It is an elaborate order, my lordship. Here, the Commissioner Panchayat and Rural Development, my lordship, and the fourth paragraph may be seen, my lord. It also appears from the report submitted by the BDO, Narsinghpur Development Block, Kachar, by letter number such and such dated 19/11/2019, and the same was forwarded by the CEO, Kachar, by such and such dated 9/12/2020. Incompleteness of PM AYG houses was due to non-execution of the balance work of the house, like plastering of the backside of the houses, coloring and floor by the respective beneficiaries. The beneficiaries were not able to make it up to the mark at that point of time due to procurement of bricks with high prices and also extra carrying of cost of materials to the remotely situated house of the beneficiary. The respective beneficiaries, with help from the local PRI members and local villagers, later completed their house and are living in, my lordship. Thereafter, I have been reinstated. After reinstatement, my lord, I was reinstated on 1st February 2021, my lordship. At that point of time, several allegations regarding misappropriation of fund, my lordship, was happened, my lordship, and I was called to appear as a witness, my lordship. Page show cause notice dated, my lordship, page 30. Again, my lordship, show cause notice. In pursuance of the government letter number such and such dated 5/1/2023, along with inquiry report submitted by the Deputy Commissioner Kachar by such and such dated 23/9/2022, it has come to the notice of the undersigned that you had been engaged in implement of various works under MG Nrega program as Rajatila Gau Panchayat, but as per the inquiry report, without implementation of the works properly, you have been found involved in gross irregularities and misappropriation government fund, my lordship. My lord, there is no specific allegation. Again, I have been dismissed, impugn order, my lordship, on page 10, page 33. This is the impugn order, my lordship, that I have challenged. Whereas in pursuance of government letter dated 5/1/2023, along with inquiry report submitted by the Deputy Commissioner by letter such and such, Sri Surajit Rai, Dadan, aggregated engineer of Rajatila GP under Katigora Development Block, Kachar, have been found involved in gross irregularities and misappropriation of government fund. No specific, my lordship. Whereas on the basis of inquiry report submitted, a show cause notice was issued against Sri Surajit Rai, Dadan, aggregated engineer, Rajatila GP under Katigora Development Block, Kachar, by letter dated 6/5/2023. Whereas reply to the show cause notice is submitted on 19/5/2023 by Sri Surajit Rai, Dadan, aggregated engineer, Rajatila GP under Katigora Block, Kachar, is found not satisfactory. On what basis it is not found? It's not satisfactory. It has not been stated also. In view of the above, and in pursuance of clause 9 of the contract agreement, Sri Surajit Rai, the then aggregated engineer of Rajatila GP under Katigora Development Block, is hereby terminated with immediate effect. So, my lord,
Page 31, whose document is that?
yes, my lord. This is, I have submitted my reply, my
You have
lord.
admitted that you have prepared bill under
No,
duress.
yes, my lord. I admitted I was locked inside a room, my lordship. And then the video, my lordship. Kindly see the order, my lordship.
No.
Order of the Honorable High Court, my
Have you
lord. I'm
filed any
coming to-
FIR to that effect?
Order dated 30/10/2024, my lord. No, my lord.
In the writ petition?
No, my lordship. The Honorable High Court has directed the state respondent
Page number?
is to.
Orders passed in this matter?
Yes, my lordship.
Page,
Order dated 19/3/2024.
19/3.
Yes, my lord.
24.
Yes, my lordship. Because departmental proceeding was initiated against the block development officer, my lordship. Because I filed a complaint against.
Wait. Which order are you referring to?
In the order of the
court,
my lordship.
19/3.
Yes, my lord.
24.
1911, my lord.
24.
Yes, my lord. 1911, 2020. Because on the basis of my complaint, my lordship, when I was locked inside my office, my lordship, I filed a complaint before the BDO, my lordship. In this case, BDO was suspended. He has been reinstated. All regular employees has been reinstated, my lordship. And
What is the status of the inquiry? Where is the inquiry report?
I had no option to sign those bills because I am not. I have no power to release my lordship. It is the BDO and other regular employees of the department. They have the power, my lordship.
Lordship, kindly page the page number 28 also. How is repeated?
No, but have you filed any affidavit or something?
No, not yet.
You don't want to file.
My lord,
Would like to file.
time and again, my lordship, Honorable High Court allowed them time. And
Was there any inquiry held?
Your Lordship, definitely an inquiry. A PIL was filed on the basis of that PIL direction given in the PIL. Inquiry was held and disciplinary proceeding was initiated against the delinquent officials.
Any inquiry report submitted?
That is not with me yet. Not with me yet. But his case is that it is admitted. In 2 occasions, he admitted.
But if he is admitted, then why did you proceed in the inquiry?
Your Lordship,
If he is admitted, you could have
not only him, Your Lordship, other employees were also
No,
involved.
my lordship, I have not admitted that I have done. I have admitted that I have been forced to sign some document before the release of that amount, my lordship. When I filed the complaint, my lordship.
You have revised the bill.
Yes, my lordship. On that day itself, I filed the complaint. I filed a complaint on 1/3/2021.
Where is that complaint?
My lordship. It is with them, my lordship. I have filed the complaint because it is admitted.
You have not enclosed.
My lordship. Yes, because I have a copy of my complaint, my lordship. Received, my lordship.
Why have you not enclosed to the
My lordship, it is because it is a department. The file, the complaint has been filed before the block development officer, my lordship.
Why have you not put it and enclose it to the writ petition?
And on the basis of that complaint, my lord, inquiry has been done.
You bring it on record.
My lord. They have also on the last occasion they admitted that complaint, my lordship.
No, if you are relying on some documents, you bring it on record. If you want.
This is one Xerox copy I have, my lordship, that
we don't know what.
Received Xerox copy of that complaint I have. In that representation, my lordship, I have mentioned that complaint. That 1/3/2021, I filed complaint. After that, the block development officer released the money. And the accountant has released the money. They have been reinstated and they are doing job, my lordship.
If you come to page 33, Mr. Kumar.
Yes, Your Lordship.
This talks about some inquiry report, subsequent there to a show cause notice.
Yeah.
Then a reply to the show cause notice. And finally, termination. But after reply to the show cause notice, was there any finding arrived at? Or
no finding.
Before in the inquiry report, did you follow the procedure of informing him or giving a copy of the inquiry report to find out what was the conclusion?
They have simply said my reply is not satisfactory.
Your Lordship, from page number 30, it appears the copy of inquiry report is enclosed here.
My lordship, I have got the report of the PIL, my lordship, and I have submitted the reply of the PIL, my lordship, to the assistant deputy commissioner. Parawise reply on PIL, page 28 may be seen, my lord. Page 28. Page 28. This is my reply to entire inquiry which was held by the additional deputy commissioner, my lordship. No specific allegation against me, my lordship. And the bill was disbursed by the BDO and the accountant, my lordship. And before disbursal of the bill, my lordship, I filed the complaint. And the incident happened just after my taking charge, my lordship. I was new to the office at that time, Rajatila.
See, inquiry report appears to be a preliminary inquiry. Unless you have served him notice that he has participated.
Yes.
But nothing is there, you have not filed your affidavit, your records are not there, you are able to.
Let me.
My lord,
File a affidavit, Your Lordship, reported I will.
my lord, from the
Copy
case
of
record,
the
my lordship,
records,
from
sir.
3 years there, even the honorable court has said that no further time will be given, my lordship. Page, my lordship, the order dated, my
Last
lord.
order said one last opportunity.
Yes, ma'am. And they also the honorable High Court wanted to know what happened to the block development officer. My instruction is that, my lord, he has been reinstated and he is doing his job, my lordship.
No, if it is required, then file it. If you do not have the.
Another 2 weeks time may be
instructions,
given, Your Lordship. I'll file.
The last order says one last opportunity.
Extremely sorry, Your Lordship. Not.
My lord, on the next occasion also same prayer they will make, my lordship. Principle of natural justice has been denied. Let them decide, my lordship. I'll file representation before them, my lordship. That impugn order must go, my lordship. And in the they can, as I am contractual employee, my lordship, on the other grounds they can decide my fate, my lord. Because all the regular employees are doing job, my lordship, and I am the scapegoat, my lordship, for being contractual employee. Even the accountant, my lordship, he has been also reinstated.
Where is the order passed in WPC 8618?
My lordship. Page 16, my lordship. Page 16. And the allegations, my lordship, before 2001, when I was suspended at that point of time. I have filed representation, my lordship. Let them decide on the basis of my representation, which I have filed on 19/5/2023.
Where was the earlier order passed which was interfered with by the court?
My lordship, earlier order, my reinstatement order, my lordship, passed. Earlier termination order. That, my lordship, I have not annexed because it was not much relevant because it is the earlier occasion, my lordship. I was then in a different Gram Panchayat, my lordship. And I took charge in the new Gram Panchayat on February 2021. My prayer is that, my lordship, let them consider my representation and decide afresh. And because they have stated that my reply is not satisfactory, but it is not a reasoned order, my lordship. At least I must have a reasoned order why it is not satisfactory.
Yes, what do you want to do?
Your lordship, 2 weeks time, last.
We are, but you'll have to pay cost. Hard counsel for the respondents have been granted time to file their benefits. Same has not yet been done. On 26/11/24, the respondent departmental counsel was granted 2 weeks time as one last opportunity to obtain instruction. Today also, when the matter is called up, no instructions are available, and the learned additional lady has represented the respondents praying for further time. Considering that the challenge before the court is a challenge to the termination order, we permit 2 weeks further time to the respondents to file their affidavit and obligor in the file an affidavit. So this is, however, subject to payment of cost of ₹2,000. We deposited before the District Legal Services Authority, and receipt will be placed before the court. Just after 2 weeks.
My lord, any date may be lordship fixed, my lordship.
After 2 weeks, you are entitled to make a mention.
Yes, my lord. Highly obliged, my lord. 18 also, my lordship. This is the impugn order, my lordship, is on page 13, my lordship. This is principle of nature, violation of natural justice, my lordship. Their reason is that whereas it has been reported by Sri S.L. Laskar, director, joint director of this commissionerate, wide his inspection report on 13/1/2021 and approval of the Panchayat and Rural Development Department by letter number such and such dated 6/2/2021 that Sri Badaruddin GRS and in charge secretary of Ratabadi Gau Panchayat under Dullabchawar Development Block Karimganj district has been found involved in an untoward incident that had taken place on 7/1/2021 during the field visit undertaken by S.L. Laskar. My lordship, untoward incident is a very, my lordship, superficial, my lordship, allegation. What is untoward incident, my lordship? This is a clearly violation of natural justice, my lordship. No show cause notice was issued. Nothing has been issued. I was suspended, my lordship.
You are suspended.
I was terminated, my lordship.
This is the terms of the contract. Where are the contracts?
Your lordship, impugn order was passed on 22nd of April 2021. He filed this writ petition on 31st of August 2023, your lordship. Whereas contract period was maximum for TCC 5 days.
That prior to I was, my lord,
Otherwise
pursuing
also
the
it is
department,
time
my
bound.
lordship.
Where is the contract agreement?
My lord, contract agreement has been, because it was outdated 10 years before, because I have been working continuously more than 10 years, my lordship. My first appointment, my lordship, was made on 34/2010, my lordship. Page 10, annexure 1, my lordship. Continuously for more than 10 years.
Terms of the contractual engagement, where are the
My
terms?
lordship. Thereafter, my lordship, it has been extended, my lordship, time to time.
Right.
Second, my lordship.
Where are the
Annexure
original,
12.
where are the original terms of contract?
That is over, my lordship.
Then where is your claim?
Page 2, annexure 12, my lordship. In partial modification of this office earlier order, file number such and such dated 10/9/2019, and for smooth running of the day-to-day routine works of Ratawari GP Sri Badaruddin GRS of the said GP is allowed to perform the duties of GP secretary till posting of regular GP secretary and directed to take over the charge from Sri Miftauddin Majumdar. So extended, I have been receiving salary also, my lordship. And the Honorable High Court directed them to submit necessary document as to on what basis I was extended and I received salary, my lord. I have been receiving salary for more than 10 years, my lord.
Maybe, but your entry into the, on what basis were you appointed?
My lordship, I was appointed in contractual terms, my lordship.
When-
Time to time, without any formal order, my lordship, my terms of engagement were extended, my lordship, and I was receiving salary.
That doesn't give you a right.
No, my lordship. My
You're right.
grievance is that, my lordship, at least, my lordship, this principle of natural justice, I have that, my lordship. They can terminate me, my lordship. There are judgments of the Honorable High Court, my lord, recent judgment, my lordship, where also, my lordship, it is held that the principle of, I am entitled to the safeguard of principle of natural justice, my lordship. This is the judgment.
You are entitled, but before that, you show us how you are appointed, what you are working. There's nothing here. What terms of conditions are there for your employment? Merely because you are working somewhere, nobody can touch you, and you are complaining about principles of natural justice. Not to talk about the delay.
But I have annexed only, my lordship, the page 11 is
It's up
my
to you.
appointment
You want
order.
to annex it, you annex it, or we are dismissing it.
My lord, then I'll submit the.
After 2 weeks, enabling the counsel for the petitioner to bring on record relevant documents to show the terms of the contract pertaining to his engagement as. What were you engaged as?
My lordship, I was engaged as GRS, my lordship.
What is GRS?
My lord, accredited engineer. Sorry, my lord, accredited engineer. Oh, there is the word. No, my lord, sorry. Gram Rozgar Sahayak, GRS.
He was appointed in Ram Rozgar
Sahayak.
in the district of Paringal. In the DRDA, the district of Paringal.
At that time, it was DRDA. Now it is under Panchayat Rural Department.
Mr. K. Kumar originally appeared for it. This after 2 weeks.
So in this case, lordship, in the earlier date, lordship, Dimahasa Council was instructed to examine on court's order, lordship, whether this matter is covered or not.
Where is Lima House of Council?
The minimum is 17 or 20.
Yes, Lima House. What do you say?
Lordship, regarding that, we have already submitted the supplementary demand, Lordship. The demand means.
So he's produced some judgment order seeking a disposal in similar terms.
Yes, Lordship,
Based on the same instruction, this was disposed of.
Close this matter.
Lordship.
Lordship, regarding item number 21, lordship, I have got one information that the petitioner is no more, lordship.
But item 20
Item 21, lordship.
and item 21, it is submitted by the council to the, that the writ petitioner when so long to be during the pendency of the writ petition has expired. He that some time be granted to take necessary step, bring in the legal aid, substitute the legal aid. Matter be listed after 6 weeks.
Item 21 is closed, lord. So 20 is closed.
20 is closed, yes. 21 after 6 weeks.
My lord, in this matter, my lord, I am praying for 3 weeks time, my lord, to file our affidavit. Because finance notification has been put to challenge here, my lord. Matter pertains to, my lord, payment of minimum pay scale, my lord, arising out of the judgment in Upendas, my lord.
Whereby finance said that no new cases. That
No,
notification-
not that
That
notification,
is-
my lord.
Then
It is a notification prior to that notification, my lord. By which, my lord, all the petitioners, my lord, who are grade 3 and grade 4, all have been granted same pay scale, my lord, same fixed pay, grade 3 and grade
which
4.
is the notification?
And for that pay, page 43, my lord. The petitioners before your lordships are tax collector, junior assistant, driver, etc., my lord.
Third, department. Writ petitioner to challenge the notification of the laws dated 3rd October 2003, page 43. And the respondent, finance department, counsel for the finance department, or to the submit that he would like to file an affidavit for 3 weeks time. Considering the prayers made in the prayer of the council for finance department allowed to be listed after 3 weeks. Mr. is doctor for PNRD.
I'm so obliged. my lord.
May I please election? Hello, matter pertains to selection and appointment to the post of revenue Sharastadar and administrative assistant in the establishment of district commissioner Morigamal. My prayer was very limited, my lord. For issuance of a direction to the district commissioner, my lord, to fill up the post.
Lordship, we have received the instruction and Lordship, the general administration department would be a necessary party here, Lordship, because the selection board is concerned with general administration department, Lordship. We have issued the advertisement, but the selection,
Who are you representing?
Lordship, I'm representing the respond number 2 and 3.
But GAT is a party here. Respondent one.
Yes, Lordship, but there's a standing council and the name is not shown in the cause list, Lordship.
Beside you,
I have called it, Lordship.
My lordship, I have just been informed. So I've come, my lord. So my lord, can a copy be given? Because otherwise what happens is, my lord, the list it is not shown. Our name is not shown and they have not served us a copy. If they serve us a copy,
you
my lord,
don't
we'll.
have copy.
They have not served us We a have copy. served copies, my lord, and accordingly they have sought, my lord, times for several occasions, my lord, to get the instruction.
No,
my
no,
lord.
you serve copies on the standing count.
I don't think so. We have served the copies, my lord.
No,
no.
Copies have been served to
When
me,
we ask
to
you a
the
question, give us
GA.
an answer. The question is not whether you have served any copy. Question is, have you served copies to the standing council?
I'll serve it.
And according to my instruction, Lordship, both the posts are vacant till date.
Right, let him get his instructions.
Yes, Lordship.
Mr. Gretman for the petitioner. And Ms. Sharma for respondent 2 and 3. Mr.
2 and 3.
For respondent number 1.
Vinala.
Mr. Kupan submit that extra copies of the writ petition has not been furnished to the him. Consequently, not complete his instruction. Counsel for the petitioner submit that you will serve copies within the course of the week.
Vale.
Will you serve copies within course
Yes,
of the
yes,
week?
please.
In the course of the week. Matter be listed after 3 weeks, enabling the respondent to complete his instruction.
Lordship, just one more thing. Can SCGAD be reflected? Because then
We don't know you.
many cases come.
You take you are appearing here. We have recorded your name. You follow up the list. Everything can be done by the registry. All names cannot be recorded. Constraint of space. Right? Registry will endeavor to reflect the names of all councils, including the standing
Lord-
council, DAD.
Lordship, if possible, my Lordship will kindly fix a date.
Based on 20, it has to be in July then. We are in the last week,
Yeah, last week of my Lord, June, my Lord, if possible. my Lord.
not possible.
Leave it to Lordship. If possible, in the last part of June, my Lord.
23rd
My Lord.
June.
Deeply obliged. My application.
Lordship, I placed the latest instruction. We have sent the pension proposal to the finance department, treasury. Lordship.
It has been sent.
My lord,
It has been sent to the finance department.
yes, my lord. Let a date be fixed
After
4 weeks. For it.
Mr. S. Sahu, Learned Counsel. Mr. D. Bora on instruction submit. Mr. D. Bora was instructed on instruction submit. That the Commandant Assam Police Battalion has taken steps, has forwarded the pension proposal. The Office of the Director of Accounting ID memo number 20 dated 17/3/2025 for grant of compassionate family pension retirement benefit. The Council for the Pensioner therefore submit that the matter be fixed after 3 weeks, enabling him instructions on submissions made by the council respondent. At least after 3 weeks.
The petitioner.
You have filed your reply.
No, they haven't filed the affidavit.
Huh?
On the last 6 occasions, they took adjournment for filing affidavit.
Yes.
My lord, we have not received the instruction, my lord.
The same
My lord,
submission on the last
otherwise also, my lord,
consecutive 6 dates.
from the speaking order, my lord.
Yes.
Hmm?
The impugned order is reasoned, my lord. Affidavit may not be necessary.
Where is the impugned order?
Page 107. May I read it?
Why are you challenging this order?
Because I was not allowed, after I have withdrawn my resignation, I was not allowed to rejoin the services. And later on, I was allowed after several years. But my absence period was not counted for seniority or increment. This is the grievance. I first.
My lord, before issuing this order, my lord, he submitted an affidavit.
He is reflected.
Yes, my lord. So on that basis only, he has been allowed to resume. Otherwise, once he resigned, again, he has been allowed to resume, my lord. And he submitted a affidavit to that effect, my lord. Period of absence with effect from so and so till his rejoining will not be claimed for any purpose.
I tendered my resignation on 1/12/2017 with effect from 31/12/2017. I have withdrawn before acceptance of the resignation on 27/7/2018.
Do you deny filing that affidavit?
I was asked to file an affidavit stating that no salary, no pay.
No, don't waste time. We are dismissing your petition.
I have not.
You have filed.
I have not consented to not to count the absence period for the seniority work.
Your consent is not relevant. This
No,
order
no
has
pay,
been
no
passed.
work.
My lord, he
I
has
have only
filed
consented to-
affidavit. What consent, my lord?
You have filed your affidavit before the authority.
It should be in fact dismissed with
Where
cost,
is
my
the
lord.
affidavit?
No, I haven't filed an affidavit to that effect that the.
Where is that affidavit?
I don't have.
Why?
When I filed an application, I was asked to file this an affidavit, not claiming the salary for
Where
the
is that
absence
affidavit?
period. So no copy is with me.
You get a copy of that affidavit from
Yes,
the.
my lord. I can get.
Why don't you get these instructions repeatedly? These matters keep on coming. Every date you are asking for instructions. Look at these 4,
Yes, my
5,
lord.
6 dates.
I have already
Last
communicated,
consecutive
my
6
lord.
days.
So your communication doesn't happen. All we want is that affidavit. If you could have shown, we could have closed this matter.
Yes, my lord. Now
So you are arguing.
this
You
time,
are arguing on the ground that he has filed an affidavit.
yes, my lord.
What basis are you arguing?
This affidavit, copy of affidavit, I will obtain, my
No,
lord.
no. What basis are you arguing? Because you have not received your instruction. How can you argue?
But from the order, my
That
lord, it can be.
That order doesn't require any arguments. It is there in the order.
Yes,
He's
my lord.
challenging that.
Yes,
He's saying that I did not say so many things in the affidavit.
But my lord, on what ground he is challenging? Because he himself is filing an affidavit to that effect. So if the veracity of
Where is that affidavit?
yes, my lord, I will obtain the affidavit, my lord. You get the affidavit, my lord.
Get it by next week.
Yes, my lord. Yes.
Heard counsel for the petitioner, Mr. D.P. Bora. The petitioner is put to challenge the speaking order dated 3/12/2022, whereby the resignation submitted by the petitioner was permitted to be withdrawn and he was allowed to join with the rider that the period of absence with effect from 1/1/2018 till the date he resumes duty at Morioni CHC Community Health Center will be treated as within quotes, no work, no pay, quotes closed, and the period of absence will not be calculated for any purpose whatsoever. He will have to serve for a minimum period of 10 years, the date of resuming his duty as MNHO-1. Petitioner is agreed by the conditions specified in the speaking order. Permitting him to withdraw his resignation. Counsel for the Health Department submitted instructions that are still awaited. So since from a reading of the speaking order, it appears that an affidavit has been filed by the petitioner. Stating that period of absence with effect from 1/1/2018 till his rejoining will not be claimed for any purpose, and that he will be in service for a minimum of 10 years to the Health and Family Welfare Department from the date of resumption. Let this affidavit and that affidavit as submitted by the counsel for the petitioner, having been submitted before the authority without making any copies, without keeping any copies thereof in the petition, the starting counsel health will complete his instructions and apprise the court on the next date as to whether such an affidavit that effect was filed and is available in the records of the department. Please again on 13. 6.
My lord, 6, I have some problem, my lord. 13.
All right, 11. 11. Get it.
11/6.
11/6.
My lord, can you be on 13? Actually, my lord, my mother is undergoing knee replacement operation on 7th, my lord.
All right, but it.
Yes, my lord. Obliged, my lord.
Obliged.
In this case, the respondent bank has filed the FDD today itself. My lord. I have received it and maybe allowed 3 weeks time to file a reply, my lord.
Mr. Islam.
My lord, legal aid counsel.
Legal aid. Sir?
Yes, Lord.
Yes. Bank?
Yes.
Yes.
All the respondents.
What is your claim here?
My lord, I have challenged the removal order of the petitioner.
Removal. Legal aid count. Grave liberty of the court file the further affidavit at high court.
3 weeks time.
Fair amount of treatment by the response. This affidavit is on record.
Yes.
Not on record, my lord. Just
No,
today they have filed.
No,
It has come on record. I filed a requisition slip.
Well, the date may be given, my lord.
You file it first, then you make a mention.
Obliged.
So we're not going. We're gonna go.
Lord, state is yet to file their response. Your Lordship, we have received the parallel summons, we'll be filing it.
The rule is issued already.
Your Lordship.
Rule has already been issued.
Notice of motion was issued on 20/12/2024.
This is item 29.
Yes. 29.
WPC 6934.
Yes, my lord.
Rule issued by order dated 20/12/24.
2012. Yes, 2012, it was moved, my lord, as a motion, I said.
Rule was issued.
Rule was issued.
Then by order dated 2012/2024. This court had matter therefore be listed for hearing after 8 weeks. Meanwhile, the
records
respondents are permitted to file their affidavit. Let me file it within 4.
Matter, Your Lordship, on the last occasion, the respondent took some time to file, to obtain some instruction.
Lordship, we have not received the instruction.
So what is to be done?
Lordship may kindly grant 3 weeks time to file affidavit.
3 weeks.
Yes, Lordship.
Short date may be given, Your Lordship.
Counsel for respondent, pray for further 3 weeks time to complete her instructions. Matter be listed after 3 weeks. MS so and so appears for the writ petitioner, so and so for the respondent. Yeah.
Obliged.
May I please, Lordship? In this matter, the affidavit will be filed during the course of the day.
Mr. Richard Ahmed for the petitioner, MS Des Burrell and its submits that affidavit will be filed during the course of the day.
Yes, Lordship, now.
That view of the matter stands deferred to be listed after 2 weeks. Do you want to file a reply?
Yes, fixed date may be given, my lord. Emergency is there, my lord.
You file a reply, we'll make a mention, we'll get listed on a weekday. Listed, deferred to be listed after 2 weeks, enabling the petitioner also to file rejoinder affidavit. The affidavit proposed to be filed with the respondent, if we advised.
Obliged.
Lordship, we have instructed to obtain 2 weeks time, Lordship.
Yes. MS M. Bhattacharya, learned counsel. We have an reduced the prayer for further 2 weeks. Prayer made is not objected to by the petitioners, least after 2 weeks.
Lord.
For
1, 2, and 3.
1, 2, and 3. You are also there?
Dip se dekhiye, Lord.
After 2 weeks, let it come.
Please, Your Lordship. The petitioner before Your Lordship is RPF constable, my lord, who has been found medically unfit. And therefore, my lord, but however, they have been found medically fit for appointment in ST1 and below job method. After that, my lord, the impugn order has been passed. Annexure C, page 14. Page 14, Annexure C.
What for? Page 14.
14, 1-4. Annexure C.
Who is the petitioner?
The serial number 1. He has been appointed as a cook, my lord. My lord, Your Lordship, now kindly see his medical certificate, my lord. It's clearly stated, my lord, he is not fit for cook actually, my lord.
Where is the medical certificate?
Annexure A, page 12. The second part is the advisement. Not to do.
Why do you say that he is not fit to be a cook?
Because, my lord, the nature of work, my lord, as a cook, my lord, he has to run, he has to
run?
lift, etc. also, my lord.
He running and jumping. What is a cook got to do with running and jumping?
Even weightlifting is also there, my lord.
Weightlifting.
Weight bearing activities, because huge food will be prepared, my lord. And he is under surgery, my lord. Still rod is there. So at these circumstances, my lord, it is not
Lordship,
possible.
in this case, I am awaiting instruction not received, Lordship. We got some time.
The only the thing is that, my lord, for the last 3 months, we are not getting salary, my lord.
But you have not joined, I think.
Because I cannot join, my lord. I am under surgery, my lord. It will be very difficult for
How
me.
will you get your salary?
Yes.
If you don't join?
My lord, I can be accommodated to other job. There is a notification, my lord, where I can be accommodated, my lord.
Which clause? Which clause?
My lord, is 19.6.2. 6.1, my lord, and 6.2 is the relevant. In the case of medically unfitted D category as running staff, preference for absorption may be given in the following categories: power controllers, assistant loco foreman, instruction in journal school, janitors, sedam, job recorders, telephone clerk, etc. my lord. Clerks in control office, hostel warden, hospital superintendent, etc. etc.
This was the alternative employment given to him, Lordship, page 13.
But as a cook,
page 13.
have been found fit for C1 and below category of job.
You are not fit for present category of
Present category. As a RPF, I am not fit.
They were RPF constables.
Constable. As a constable, I have not been found
Not fit, and therefore thereafter this office order has
but has been found fit in the last line, but is fit in category C1 and below.
What is C1?
Those post, my lord. Including Cook, my lord. I'm admitting it.
No, what is C1? Cook.
These are the job, my lord.
19.
6.2, page 19.
Yes.
Lordship, I have to take instruction. Waiting also.
Do it. Why don't you file a representation?
I have filed, my lord.
What
It
orders
is-
were passed?
I have annexed here, my lord, my representation.
What orders were passed?
Nothing, my lord, the impin order has been passed. Annexed D page 15,
Where is the representation?
my lord.
Where is your representation?
Page 15, annexed D.
Then what order was passed?
Nothing, my lord. It is still pending, my lord.
Then dispose it off.
Yes, my lord. It can be
Lordship.
disposed of.
Next page, Lordship, 8.3.25 order, Lordship is there, Lordship.
Huh?
Next page, page 16.
Yes.
Here it is not written that his representation has been considered, but this is approach above you are hereby spared on 8.3, this letter has been passed. On being allotted after screening by the screening committee, and you must report to inspector.
Yes,
No,
Let
there
me
is
have,
no reference to the representation.
That's why, Lordship. Let me have my instruction on what happened to this.
All right. Third, appeal for the profit. Then a CGC appearing for the railway.
Lord.
Pray for further time. To complete it. It appears that the petitioner was found not fit to be appointed as railway constable. However, he was found fit for job specified under C1, category C hyphen 1 in the as per the Master Circular 25. In terms of the jobs specified under the Master Circular, more particularly in paragraph 6.2, several categories are mentioned. Stop. There is no mention of the category, there is no mention of a cook in the same category. So the petitioner filed a representation dated 1/3/2025, which claimed and claimed the authority. Meanwhile, the authority to the impugned order dated 8/3/2025, where he was asked to report as a cook within bracket level 3 on being allotted after screening committee, and he must report on 8/3/25 without fail. So it is submitted by the counsel to the petitioner that a cook requires he's the patient who underwent surgery for spondylitis.
Yes.
Cervical or lumbar?
Malad lumbar, LS, L5SI.
Spondylitis.
Spondylitis.
Due to decompression and fusion. And he is not advised to do weight bearing activity. He submits that the cook will be required to perform weight bearing activity as the food to be prepared is usually in huge quantity, requiring movement of utensils, heavy utensils. Right. Let the respondent complete their instructions. 2 weeks further time.
Lodge.
2 weeks.
Lodge.
Only the date may be fixed, Malad, because we are not getting salary. Yes.
June. 13th June.
Yes. Next bucket, no?
Please, Lordship.
Now, Lordship, my instruction is on 26/5, Lordship. He visited the office of the chief engineer, and now it is the pension proposal is in process, Lordship, under process now. Cooperation from the petitioner is required, Lordship.
Pursuant to the order dated 5/2025, the petitioner submitted the necessary documents before the office of the chief engineer irrigation, and as submitted by the learned standing council irrigation, the steps are being taken for process of the pension of the respondent authority of the petition. For further instructions, council will pray for
3 weeks time.
3 weeks time. Prayer made is allowed, and will be listed after 3 weeks.
RR section on behalf of for expert number 4.
Accountant General. RR Sakya for Accountant General, you turn up for
Number 6.
Let this matter come on 20th or 23rd of June.
20.
20. Obliged, Lordship.
Obliged.
Lord, I am appearing in item number 40, my lord.
Yes.
Earlier notice was issued and a limited interim order was also granted, my lord. Now, my lord, what had happened on first is the
You are appearing only in one item,
item 40, my lord,
not the other.
not the other.
But the benefit will go.
My lord,
So the benefit of your argument is to be conferred.
my lord, it's a very simple point. The finance department wants to fill up some posts of inspector of taxes, my lord. Now, the feeder category post is the senior assistant. Now, my lord, there was an amendment of the rule by which graduation has been made mandatory. Now, petitioner who is otherwise eligible, he is graduate everything. He is in the feeder category. But since the number of posts is 60, therefore zone of consideration is 240. That way I do not come within the zone of consideration. But what the state has done, my lord, those persons who are not graduate, their name has been enlisted. Persons who have retired, their names have been enlisted. Persons who are overaged, their names are enlisted. That is how I'm out of the zone of consideration. Otherwise, I am very much in. Now, state has filed an affidavit. The state's case is, as a one-time measure, they have given this benefit to the ineligible candidate. Well, this is not charity. State can't behave like this. What is the right of those people to even apply for this post? When eligible persons are there, how come you are bringing in ineligible persons? Today, my only prayer is, my lord, on first the exam is going to be held, departmental exam. I should be allowed to participate without subject to the outcome of this case. That's all, nothing beyond that.
240, my lord, that is the least they have prepared, my lord, at the ratio of 1:3. For 64, 1:4. Yes. Before that, if can.
1:4 with 4 persons.
Yes, vis-a-vis 1 post. Well, before that, if it can be hard, my lord.
Why the name was not in?
Well,
why are they not allowed?
My lord, pursuant to that, my lord, decision taken by the government, that my lord, as a one-time measure, government will be allowing both, my lord, graduate as well as undergraduate to participate in the selection.
So,
my lord,
no consideration on seniority.
Seniority come,
Actually, my lord, what had happened, lordship?
Those persons were not there, you would have been.
Yes, my lord, out of 240 persons, my lord, who have been enlisted, only 68 are eligible. The rest are all ineligible.
Going by the, my lord, educational qualification.
No, educational qualification and overage. Because the rules prescribes age also.
The policy.
My lord.
You are challenging the.
Item number 38, that policy is itself for the challenge.
Affidavit is probably the affidavit filed in 13 and 40 that will cover. Because stand is same.
My lord, my humble submission is, I am not calling upon your lordships to take a call. My lord, the balance, the equities can be balanced, my lord. Let me participate subject to the outcome of the case. If I succeed, my lord, then my candidature will be considered. If I do not succeed, then they will go ahead with the result. Otherwise, there is an order that they will not finalize this election without leave of the court. That's why I'm saying, my lord, I don't think any prejudice is going to happen to anybody.
In that case, well, let it be on 30th, my lord, I will have the instruction on that point. If the authority will have any issues, my lord, if they are allowed to participate. It's a written examination.
Written departmental examination. The rule prescribed, my lord, the exam.
Friday, my lord. Day after tomorrow.
I don't think, my lord, any prejudice will be caused. In any case, you cannot.
What interim orders are there?
I should be allowed to participate.
No, interim order is, my lord, not to finalize.
Not to finalize. Not to finalize.
Not to finalize.
Without leave of the court. Well, that will not give me any right to participate if I do not participate in this election.
Is there any age bar or something?
Yes, 45 years.
How old are you?
I'm
no, not 45, 50.
50, now it is 50.
50. Amended.
No. What we are thinking is, if you are challenging the.
Yes, if it goes, my lord, entirely it goes.
If we set aside everything.
Yes.
Whoever has appeared, the process will start afresh.
No, my lord, what I was trying to say.
If we allow but if we allow the policy, if we interfere with the policy or the order and hold that no people not qualified should not be allowed, then the entire exercise they will have to start fresh. Number one. Number two, unless you say that no, by first or second you will be overaged or depart or anything like that.
One more. That's it. That's it.
He is 47
No, my lord,
years.
my lordship, that there is a question of law in this case involved. Lordship knows in the Rangaya's case.
What we are saying.
No, I have followed.
This is a departmental exam. It is not by APSC or UPSC that lot of effort or time will have to be taken to hold another exam. It's a departmental exam. So if we hold that no, these candidates are not eligible, and your candidates and other similar situations are eligible, the entire process.
Well, in fact, we have made a statement, only 68 are eligible.
That's right. But in case we hold that
selection is bad.
No, if we sustain this election made, then your effort of sitting for an exam is great. Otherwise. So,
no, yes, that is a possible way of looking at it, Miller. Another possible way was without causing any prejudice to anybody.
But what is the point otherwise?
That's true, Milord.
The
Prima facie, it's an open and shut case. There is no question of government taking in one time. Otherwise, government is very.
has traveled and lot of things have come. That Agarwal matter.
Anyway, my lord, then they will not. There is an order.
The interim order will remain. They will not finalize. Meanwhile, you whatever counters you want to file, you file.
They have filed it.
Already filed in item 40, man. Probably that will cover a thing, man. Because the ground is same, man. That policy decision, whatever was taken for electing, man, as a one-time measure, that is not still otherwise. We have taken the views of the political department as well as judicial department, and it was
No,
taken.
my lord, the judicial department's view is wrong. In Khosa's case, Supreme Court said, my lord, when it comes to holding a higher post, a higher qualification can always be prescribed. That is 1974 1 SCC. Ranga's case has recently been overruled. Now it says the rule holding on the date of selection that will be applicable. So from both point of view, my lord, Khosa and the Rangaya's judgment, my lord, the stand of the state is wrong. There cannot be any question of ineligible persons being given an opportunity in the. There cannot be a policy decision which is prima facie or violative of Article 14. That's a simple case.
On hearing them,
Then Lordship will
hearing the
give a date for. I don't think it will take any longest time, my lord. Even at admission, Lordship can dispose of these matters. In that case, can I pray for my lord 12th of June, my lord? Oh, it's a bondoni.
No. They're restricted.
Huh?
Restricted.
Oh.
We'll hear you in July.
July, my lord.
Oh, this will require.
After reopening.
So I understand your anxiety. Therefore, I was asking you whether there is a cutoff for age or anything like that.
Yeah, no, it's not that by July I am going to be rendered overage. No, my lord.
Even if we can permit you today, also, but if you appear, it doesn't give you any benefit unless we decide the matter.
Whole hog. Either you remain or it goes.
No, unless you are instructed that this examination is held every 2 years or something.
No,
And
no. In fact, my lord, this selection was not held since 2012. After 12, now it is being held.
In that case, on 17th of July, Thursday.
How?
Oh, yeah.
You are not filing affidavit.
No, they are filing.
So in between, my lord, if required, I will file, my lord. Let the.
If required, you decide and.
No, that's why I'm saying. If they send that, my lord, they will.
hearing.
If they provide some further instruction, I will file it
No,
before
in
the
this
occasion.
matter, they have filed affidavit.
All right.
We have filed reply also.
Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. Baxter and Mr.
Taxation, my lord, financial taxation.
National AG for Assam, appearing for the tax finance and security part. Respondents have completed, the parties have completed their PD and will be listed for admission hearing on
17th pillar.
17th July.
Yes. Deeply.
17th
July. Interim order will continue.
Interim order passed earlier will continue until further order.
Deeply.
Yes.
This matter is a compassionate appointment.
Compassionate appointment, that circular, does it hold field? 24 September circular? Is it applicable? You are
No.
not aware?
24 circular is with me, Lordship. It will applicable, Lordship.
Then subsequently there is a judgment by a coordinate.
Court number 4.
We don't know which court, but.
Yes, Lordship. Is passed in the writ petition 342 of 2025, Lordship.
So there is a circular today.
Yes, Lordship.
So have you challenged the circular?
No, the petitioner have not challenged.
Not challenged.
Then notification will be applicable.
Lordship, this is something different. Petitioner's name was on the second.
The state has taken a policy decision.
Yes.
Compassionate.
Yes, Lord.
That's the end of it. How can we direct the state to take unless the notification is questioned? You have not challenged the notification. You have not challenged it,
Yes,
it has
not-
taken a decision.
Yes.
Then, once a decision is there,
Yeah.
you're not questioning the correctness, can there be a separate direction by the court that you consider its case, yours that notification? No. So we dismiss it or what?
Grant me some time. I have to take some instruction.
Grant you some time, all right. 3 weeks. To enable the counsel to the petitioner to complete her instruction in view of the notification. Is it notification or what?
Office memorandum,
Memorandum?
18 September 2024.
18.
Yes.
18 September 2024, whereby the state has taken a decision not to grant compassionate appointment. In
In the light of Debabrata theory assessment.
any further, the light of the judgment of the effect court rendered in Debabrata Tiwari reported it. Can you give us a copy of that?
Copy. Connect.
You give a copy to the.
Yes.
After the brief.
Yes, sir.
Deep level.
Yes.
May I please, Lordship? Lordship may allow us to withdraw the instant petition and liberty will be given us to approach this honorable court.
You want to withdraw?
Lordship.
Why?
Lordship, there is some defect in the notice, Lordship.
My lord. Counsel for the petitioner to withdraw the application. To liberty 500. Mr. Riketo. Arbitration petition dismissed.
With your vote. All right.
Compassionate appointment, my lord, pending since, my lord,
Notification.
notification thereafter, my lord, one return was disposed of. I have enclosed page 99, my lord. Page which was pending. That may be disposed of by the district level committee or state level committee.
One thing is there, Lordship, date occurred in 2021. Now, Lordship, after this OM of 18 September 2024, after 2017, 2017 is the benchmark. So after 2017, as the date occurs 2021, the compassionate family pension will come. And Lordship, as per our affidavit, page number, para number 4, the answering deponent states that the wife of the petitioner, late Debokanta Bora, Srimati Senimai Bora, has been drawing compassionate family pension since the death of her husband. The wife is already getting the compassionate family pension as per para number 4 for affidavit. So again,
No, your grievance is that you were recommended by DLC.
No, pending in the DLC.
DLC.
No, district level committee, Gulaghat.
So has the DLC taken a decision?
our affidavit does not say anything in regard to DLC, Lordship. And
After the affidavit, my lord, this honorable High Court on T425 passed an order.
What is that order?
It is para 9, my lord, the relevant page is 99. 9.
So we are not going by this order because this order is not to be taken as a precedent. That is reflected in the order.
Well, let the DSP may consider my case.
So where have you stated that? Where have you stated that it is pending before DLC?
My lord, commandant filed an affidavit in opposition, my lord. My father was the constable in the 11 APBN.
yes, in the affidavit, after receiving the petition, the deponent was informed verbally to the applicant that the opportunity of appointment of compensation grant has been withdrawn by the government. Dated 31st October 2017. Para 4, Lordship. Everything, the para 4 speaks about everything.
When did your husband die? Husband or father?
Father died, my lord, 21.
2021, 6/6/2021.
6/6/21. So he applied on 17/6/21. Oh, postponement.
Where is it there in the notification? Which part? Yes, Mr. Burwa,
What's it? Notification of 2024 notification.
you read your para 4.
Yes. I got submitted a written petition to the office in respect of that this father was employee of 11 Assam Police Battalion expired away. When he was in his service, late Departmental had left 5 family members, including the applicant, and since then it was reported that they have been facing financial difficulties. Accordingly, the applicant has sought for appointment in the police department on compassionate ground as the subject. After receiving the petition, the deponent was informed verbally. The deponent was informed verbally to the applicant that opportunity of appointment of compassionate ground has been withdrawn by the government notification. So and so 31st October 2017 of Secretary to the Government of Assam Pension Public Grievances as per rules and so. The application was also informed that applicant also informed that the answer authority will not be able to take action on it on the basis of the above mentioned ground. And deponent said the wife of Devakanta Bora, Srimati.
You have not read your affidavit. It appears. You have read it for the first time.
No, I read it before. So.
Are you sure?
Yes.
Then tell us what you have written in your affidavit.
Basically, as per our this thing, government notification, we have withdrawn the concept of compassionate family.
Where is that notification?
Lordship, no, Annex RD, Lordship.
Yes. Which part of the notification says?
No, basically, Lordship, that's what, Lordship. This Annex RD is basically 31st October 2017. So, not this one, say 18/3/2024. That is the actual OM, which tells about that compassionate.
What have you written in your affidavit? Para 4.
No, say, I may be filed to, I'll have to file one additional affidavit by annexing that.
We have that. We are asking you what have you stated in your affidavit?
Yes, that we have already withdrawn.
Withdrawn on which basis of what?
But the Lordship, this 31st October 2017 revised comprehensive guideline for family pension in respect of government servant who died in service pursuant to compensatory family pension scheme. Basically, this is Lordship comprehensive revised guideline. But that does not mean that that OM does not exist. That exists, Lordship.
You forget that this court was on the other side. So, looking at you, I can make out you have not read your affidavit. Read it and come back on Friday. Tell us. Tell us. On Friday, read these are your papers you should read.
No, I have already gone through. But this, the annexer which has been annexed here, Lordship, is something different. Actually, that 18 September 2024, that OM, so that
we are giving you time to understand what you want to say and apprise the court.
No, sir.
Do it on Friday.
No, sir. Very well.
All right? Friday.
Money.
Read your affidavit before you make your submission.
Absolutely.
List again on Wednesday date, Friday. And the request made by the council. Mr.
Lordship, yes, he's not available.
That appears for the petition. report. Other regional area, it's after 1 week. It's the Chaudhary for the BTC. BTC.
Oblige.
Before my language starts, can it be the next week or not? Can it be taken the next week or not?
Sorry, I'm not
Yes. Yes. Any date, your lord.
Taken up.
But date may be fixed, lordship.
Be taken up next week.
Not date may be fixed, lordship. Any date.
Friday?
Next Friday, next Friday.
Friday.
Eight.
Six of
Lord.
Service completed, my lord. Service has already completed. Department file affidavit, my lord. Removal of Asa from my lord, employment without any notice or any, my lord. They have admitted, my lord.
yes.
Record was called for, my lord. Record, we have received our record and we have filed our affidavit, my lord.
He was permitted to join.
No, my lord, no, my lord.
No.
No. From 2021 January, my lord, she was not working, my lord. In our affidavit, my lord, para 5, page number 17. The deponent begs to state that according to guideline of ASA worker, the area for which the ASA worker is allotted, that area must not remain unattended. Therefore, for non-attendance of this petitioner, she was removed and the respondent number 5 was engaged as the new ASA worker for the locality with due process, and subsequently the ID number of the petitioner, that is so and so, was deactivated from the official portal, my lord. My annexure Roman 1, my lord, at page 21. This is an office order, my lord, 18/6/2021. That as per order of the Joint Director of Health Services, Nalbari, by so and so, you are hereby directed not to do any activity as ASA from today, that is from 18/6/2021, my lord. And thereafter, a general meeting of village was done, my lord, and there they have taken resolution, my lord, that is in Page number 26, my lord. Resolution number 1, the House unanimously resolved to make it the Assam Management Committee of Village Bortola number 4 a 16-member committee, my lord. Today's meeting was convened as per the instruction of the Gaon Burha, board member and supervisor, but as Asa is not present in the meeting, the House condemned her absence and expressed dissatisfaction, my lord. As the Asa has been absent from her duties since the month of January of current year till date and also remain absent from her duties for 3 months in 2018, the House unanimously resolved that her service is no longer needed, my lord. And they have taken resolution, my lord. Thereafter, another meeting was held, my lord, that is in Annexure 3, my lord. Page number 33. The public as well as the departmental
Why
authority.
do you say that she was permitted to join? By which order?
No, she was appointed, my lord, in 2013, my lord.
No, no. In your synopsis, the statement you have made,
In office, my lord.
I don't know, we are reading it. Last line, Office of the Mission Director. Hmm.
Yes, my lord, we approached the mission director office, my lord.
Hmm.
Then, my lord, on verification found that her, my lord, ID number is still active. And therefore, my lord, the mission director asked the petitioner, my lord, to approach the district authority, my lord.
Hmm.
And they, my lord, about, my lord, their own communication.
Where is that? Where is that?
Communication is not,
Hmm.
written communication is not available. And they have in their affidavit, my lord.
But in your writ petition, no such averment is there.
In the petition, my lord.
Para 5.
My lord, para 5, my lord.
Last
Page
line.
6, page 6, my lord. Therefore, the petitioner approached the office of the mission director at Guwahati.
This is just a mere statement without any supporting document.
And from the affidavit of the department, my lord, Lordship kindly see their statement is, my lord, contradictory, my lord. In the order, my lord, issued on, my lord, 18/6, page 21. Page 21, my lord. Order dated.
They have denied this statement, disputed your contention.
My lord, no notice has been served, my lord.
Huh?
No notice has been served, nothing, my lord.
What notice?
And private respondent has been appointed without, my lord, selection, interview selection in my place. No advertisement. And as per guideline, my lord, if anybody absent, my lord, remain absent more than 6 months, my lord, then notice ought to have been given. Yes. Here, my lord, they have admitted no notice. And impugn order, my lord, they have shown, my lord, page 21.
Private respondent is on temporary or regular appointment?
Regular.
How have you selected, how have you proceeded with the selection?
Order issued on 18/6, and they have admitted that I was absent, my lord, up to July.
There is an indicator of metrics for ASA functionality, my lord. In this, my lord, the assessment is given, my lord. As per the ASA assessment report received from MD NIHM Assam dated so and so, my lord, he was removed, my lord, as non-functional, my lord.
No,
That was
but
not.
removed is all right, but private respondent appointed in her place is another process
Yes, my lord, that due process was,
by advertisement.
yes, my lord, we have given in my affidavit, my lord. The resolution duly they have taken resolution, my lord, in the meeting, my lord.
Right.
Yeah.
We advertise. Will have to be
Yes, my lord, that is the guideline, my lord. Right.
guideline. Just keep the guideline.
Oh, replacement of.
Election is by way of discussion, group discussion.
Advertisement notification is, because earlier, my lord, notification was issued, my lord. Otherwise, how, my lord, candidate will apply, my lord?
You show him the,
Lost.
have you given him a copy? This is in respect of replaced ushers. But this is not a part of the
No.
affidavit. It should have been the part of the affidavit. This is how replaced ushers are to be appointed.
Now, here, my lord, the removal is, my lord, absolutely, my lord, in violation of principle of national justice.
You
That
yourself
matrix was given in this record, my lord. That matrix.
Because
Next page.
notice was not served, warning was not given.
to bring all this on record.
Yes,
Why are you not bringing this on record? This is the relevant part.
my colleague has filed this affidavit, my lord. I am appearing today only in this case, my lord.
Heard counsel for the parties, MS Kebora, learned counsel, appearing for the what is this? NHA.
Lordship.
NHF, appearing for the NHF. Submits that there is a detailed procedure prescribed for engagement of for filling up of posts. There is a detailed guideline prescribed to be followed in case of replacement of ASHA workers. And the same procedure prescribed has been followed. So, the parameters for replacement are also followed by the authority. Therefore, there is no infirmity in the procedure adopted and the orders passed towards the appointment of the private respondent. So, she, however, submits that she be permitted to bring the guidelines on record by filing an additional affidavit. He prayed for 3 weeks time. Let the matter be listed again after 3 weeks. And for personal, let it come with appeal for the respondent number 5. It's after 3.
May I please date, my lord?
23rd.
Lord. All right.
With the matter,
2020, yes, 23rd of June.
Lordship, the matter may kindly be passed over for the day.
The request made by the council for the petition, the matter stands passed over the day. And is
Deeply
sent to the
obliged.
party, it is for the state and
1 to 4.
TV Darshan. 5.
Obliged, your lord.
This case, your lordship, I have filed my Salatnama yesterday only, your lordship. Some accommodation for today, your lordship, may come up after next week, your lordship.
Today's board approved, submit that he's been recently engaged in the matter. Other set of councils are withdrawn.
No, your lordship is there.
Huh?
I'm there
You are there.
to assist him.
Has been engaged to appear in the matter. He has filed his Wakalatnama for appearance.
On 4th, your lordship. If it is not inconvenient for the court.
He prays for some time to complete. He fixed it again on 4th.
Lord. Obliged.
Mr. C.K. Borwell, state.
Hello.
Deeply obliged.
Fair little lordship. My lord, the present petitioner was the works as employee. And she served 32 years of continuous service. And she went on retirement on 30/11/2023. But pension and pensionary benefits have not been provided to her.
We'll have to hear the matter.
No, my lord, we have some judgments of the Honorable Supreme Court.
We'll have to hear this matter. You are claiming pension.
Pension and other pensionary benefits.
On the basis of Supreme Court judgment. Prem Singh. Is it Prem Singh?
No, they say that Supreme Court judgment, my lord, this Sripal and others,
Sripal and Jaggo.
and Raskaran Singh and State of Gujarat.
Yes. We'll have to hear this matter.
Lord.
We had already heard one matter, it's reserved. I think.
Yes, Lord.
So,
But it's a little bit different, Lordship. Lord, if Lordship kindly see that regulation order, Lord.
page number.
Regulation. Page number 16, Lordship. Annexure 5.
Yeah.
Annexure. In pursuance of the additional chief engineer's letter dated so and so, letter number so and so, dated 2011-80, and subject to approval of the Secretary to the Government of Assam, PWD Dispur Guwahati 6, the service of the following works as Sakidar, who have completed more than 5 years continuous service as on 31/11/99 against their names, are hereby brought to regular cadre under this division with effect from so and so in pay scale so and so. This order may stand cancelled if the Government of Assam in PWD does not accord necessary approval for this purpose. It has been cancelled, Lordship. Subsequently, I have brought the document in my affidavit. So no approval was granted. Accordingly, the concerned executive engineer cancelled this order. So Lordship will hear this matter.
Lord, they have cancelled, but Supreme Court said this type of order.
This cancellation is not challenged.
Not challenged.
But here, when there is, my lord, perhaps that would be not necessary.
We'll have to hear the matter, Mr. Mahmood, because this is a matter.
Thought that may be fixed, because I am in old age and health condition is also not good.
And actually,
You are in old age.
let
How can you be in old age?
affidavit reply से क्या दिया
We disagree with that view.
No, moreover, Lordship, they have not filed a reply also, Lordship. If they are not intending, Lordship, then it's a different. That is another.
Let the matter be
There is a
listed
Supreme Court order.
for, we'll have to hear it, we'll fix
Well,
it. For hearing matter.
Yes, for short that may kindly be fixed.
Issue rule, matter be listed for hearing. Will come in the month of July. Hearing.
May it be in June, man.
There's no point fixing a date unless because we have already heard one matter where Mr. Nayak was on the other side. So it requires substantial hearing. And perhaps if we in the meantime deliver a judgment in that matter, it may be.
In the state of Gujarat, my lord, it is clearly said denying pension to an ad hoc employee after 30 years of service unreasonable. So 32 years I have served.
We'll have to this for hearing in month of July.
Date may kindly.
Mr. In the 4th week of July. Mr. P. Nayak, additional AG appears for the state respondent, and Mr. Boro appears for accountant general. July.
Obliged, Lordship.
Against the counter matter, we file reply.
Your Lordship, yesterday I have received in the evening a very short.
It is submitted to the pleadings in the writ petition have been complete, have been exchanged. And we issue rule and fix it for here. I mean,
On 24th of July.
no fixed date. We'll say matter will be listed for hearing in the 4th week of July.
Otherwise it will not come, my lord.
It will come.
Anyway.
Issue rule. Matter be listed for hearing in the 4th week of July.
It's, similar order may pass on the second one. Also.
Similar order. 55, 56.
56 on
Same order.
Same.
55, 56.
Cases are different, of course. This is 56 regarding Assam government and the other central bank. Cases are different.
All right. Yes?
No, 56, Lord.
56. Mr. Bhattacharya, and with the other matter, Mr. M. Sharma.
Oh.
55. You are appearing 55 is what?
Central Bank of
Bank. And the 56?
I am appearing, Lordship. This is the state respondent.
State respondent.
Yeah, Home Department, Lord.
Yes. Yes, Mr. Duck.
May I please, Your Lordship, my lord?
Yes.
Before proceeding with the matter, my lord, may I request this, before filing this, this, my lord, the petitioner also, filed this, my lord, it brings this one before the authority concern, my lord. That the petitioner up till now, as to our knowledge, my lord, that has not been disposed of, my lord. May I request this honorable court, my lord, for issuing a direction to the council appearing on behalf of the respondent to apply this code, whether that deposition is disposed of or it is still pending, my lord. That deposition, my lord, you will also find a page. Page 47, my lord.
Yes.
And then subsequently, my lord, the reminder was also issued, submitted. That is at page 49, my lord.
Yes.
But in their affidavit, they have not made any statement regarding about this, whether this is rejected or it is still pending. My lord, they have not stated anything in their affidavit, my lord. So in this case, my friend, the council appearing on behalf of the respondent, he may be directed to apprise this court about whether this is still pending or it has already been disposed of, my lord.
Yeah.
So it has not been mentioned anything in the affidavit, or not clarified. Otherwise, Lordship may dispose of the matter, giving a direction to that particular representation which
So
is
you
pending.
tell us whether he's claiming disability.
Then I have to obtain instruction.
Ex gratia, my lord, compensation, my lord.
Ex gratia compassionate payment.
Ex gratia
Compassionate payment,
under
compensation.
What is the provision for ex gratia?
That is as per the guideline, my lord.
Next chapter 8.
Yeah.
Character.
Bona fide official duties. But here in this case, we have reverted that particular aspect of the matter. That in page number 9 of our.
In excess 6 and 7, my lord, that is a official memorandum, my lord. Who is provided for granting ex gratia compensation amount, my lord. The husband of the petitioner was my lord invalidated, but because of the illness, my lord, and that he lost his fine. Yeah, the NFR 1, my lord. The at page 80, my lord, the dominant upper answer, the percentage, my lord, 87%, my lord. The total, that means almost a total disability of the husband of the petitioner, whether by constable, my lord, in the CRPF. In persons of the decision of the board, my lord, is subsequently by the annexer 2, my lord, page 22, issues notice issued to the petitioner for disability of disability from service, my lord. And as per the office order, my lord, that is 24/5 to 2017, my lord, annexer 3, my lord. At page 27, it was specifically mentioned as the disability of the incumbent arose out of the official duty. As such, he will be entitled to the disability pension and other benefits in terms of the Rule 38 of the so-and-so, as well as orders issued from time to time.
You're reading from page number?
Page 27, my lord. Page 26, my lord. There is annexer 3, my lord. There is office order issued by the Deputy Inspector General of Police, my lord, Group Central. And pursuant to this letter, my lord, the petitioner, my lord, being the wife of the incumbent, my lord, submitted the application before the Inspector General of Police, my lord, filed annexer 4, my lord, page 29, my lord.
Now this, what is the position after page 26? He has been allowed,
My lord, my lord,
entitled to disability pension.
my pension, my lord. So that I am getting, my lord. That
Then
I am-
what happened?
That about it actually as this amount, my lord.
Compensation.
Compensation, my lord.
Ah.
That as per the petitioner is entitled, my lord. As this amount as per the
Annexure 7, page 30.
annexure 70.
Page 38, Lordship.
So this, my lord, is this
But this is for 100% disability.
no, my proportional, my lord, that can be, the tax amount can be awarded, my lord. As per the proportional, my lord, of the disability, my lord.
Okay.
Only. The first this annexure persecution, my lord, annexure 4, my lord, that is the first representation made before the authority concern, my lord, for requesting for making payment of the execution amount, my lord, to her. But that has been, my lord, turned down by the annexure 5, my lord, page 31, my lord. The last page 33, my last part of the letter I am facing before lordship, my lord. Page 33, my lord. Accordingly, you are hereby informed that your husband was not in active duty at the time of his illness. Apart from that, he was performing duty in cooperative shop as a salesman. Further, it has come to light that the ailment did not occur neither in course of performance of duty nor facing adverse situation while on duty. Therefore, the case causing ailment in respect of your husband does not even cover the provisions of so-and-so memorandum, that is so-and-so 21/4/2011, referring to the letter of the director of so-and-so, so-and-so, that is so-and-so. Therefore, the case of regarding the approval of ex gratia compensation amount on the disability are closed up, my lord. That as soon as this letter was received, my lord, this says he paid the petitioner, my lord, immediately submitted a representation. Page 42, page 47, my lord.
No orders have been passed.
No order, till now, no order has been, but that has been.
How soon can you get it?
Lordship,
How soon can you get that information?
at least 2 weeks, Lordship. At least 2 weeks, Lordship. With regard to the representation, 49
I
and
thought next week you get the instruction
whether it has been disposed of or not. Yes, Lordship.
whether any order is passed or not. If
Next
yes,
Friday,
you
Lordship.
get the order
Next Friday, Lordship.
next Friday. Let's have it on next. The learned senior counsel up before the court that the what is the pension ex gratia?
Ex gratia, my lord, ex gratia. Ex gratia compensation amount.
Ex gratia compensation amount payable to the petitioner has not been released by the petitioner, by the respondent authority in spite of representation by Mr. S.P. Chaudhary and submits that he would like to obtain instructions in the matter as to the status of the representative file and whether it was disposed of. So let these instructions be
On 9th, Lordship, 6th, I will not be there, Lordship.
be before the court by the next date fixed. It's on 11. Have it on 11.
Always.
11th.
May I please, your Lordship?
You have placed the written arguments.
Your written argument.
Lordship, we'll file our written argument on Friday, Lordship.
Right.
Day after tomorrow.
Friday.
Lordship.
Have it on 4th.
Lordship.
Interim order will continue.
The interim order will continue until further order.
Lordship.
List on 4th, enabling the respondent counsel to complete their list on 4th. We are just saying list on 4th.
Lordship.
the request for counsel.